Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
Hello?
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
Hello?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges were watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for East Service Latino. I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
All right. I'm trying to have four. Don't raise
I don't like
You guys found the sounds early today. Welcome back.
I didn't ask you to interrupt me.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Good afternoon to you. We're going to be popping back into the courtroom up there in New Hampshire to see what's happening in this trial. As the jury has gone home. The jury has gone home for the day. Closing argument's not going to happen until tomorrow morning.
Hello?
But there might be still some spicy discussion to be had up there. So I somehow I cheated you out of your commands last time. I didn't know they weren't working. I didn't realize. So I'm sorry, but they're working now. It's great. Firegirl, handmade by Wendy. Congratulations, your first in chat. We're going to send it to internet ownership. Everything IP related worldwide is now yours to repair, not to sell, not to profit off, just to repair. You just have to fix it for the rest of us. So, why is Stubby always broken?
Because he's the guy.
Hello?
Stubby breaks because the hard drive disconnects for some reason. Let me find Stubby on here. It's alphabetical, so it should be easy.
Hello?
Hello. Okay, I think it's this one, Stubby Pencil.
Hello?
When are we going to break for lunch, Judge?
Oh, that was bad. That was bad. Stop.
Have them send someone with more experience.
The zombie apocalypse may be upon us.
I got a stubby little pencil.
It's working now. It's working. I fixed it. I don't know why it breaks. It's actually I do. I've got it saved on a NAS storage drive, and it goes offline periodically. So
I saw a chicken fight.
hey, Dog Mom, we're not going to jump to
Hello?
the new trial until after our trial is over, because I just get so much confusion from people, like little hate, little hate from people. We're like, what? Where's this trial? Has the defense rested? And we're trying to explain that it's a new trial. It's
Hello?
difficult. Who's Ricky? I see you there. How are you doing, Ricky? Hello. Why is bigger always broke? Bigger's never works. As a matter of fact, bigger only works when I push the button. It's always been a manual command.
It's bigger than you. It's bigger than me. It's bigger than all of us.
Because when we tried to build it, it just wouldn't work. It would always cut it off. So, who keeps saying hello? Well, whoever types it in chat like this keeps saying hello.
When are we going to break for lunch, Judge?
Like that.
Hello?
Why haven't I heard
Hello?
the hello? Isn't there a hello in there somewhere?
Hello? Hello?
That one. There we go. All right. Now we got it. Now you got them all.
Hello?
You can stop pushing the button. It's all right. All right, we're going to be going back to court here in just a minute. It is 1 o'clock. It's time for the judge to come back to court with the lawyers
Hello?
and
Hello?
fight some things out outside of the jury's presence. We're going to hopefully
Hello?
get some spicy discussion on that today. The mods also get a headache when we
Hello?
do two trials at once. Yes, it's difficult, but
Hello?
what we can do. So now I'm going to turn it down a little bit.
Hello?
Yeah, what we can do is possibly
Hello?
play catch up really quickly on a trial like that. Once this one stops, because we're going to have closings tomorrow. Honestly, I think we're going to have verdict tomorrow. It's going to be a Tuesday verdict, and and then we'll be able to pick up where we left off. All right.
I was kicked back, taking it easy.
There we go. All right.
I don't like podiums, Your Honor.
Hello.
It's funny. It's funny. Chet Auntie is about to pull this stream over. This is why we can't have nice things.
I saw a chicken fight.
Yeah. Well, let's focus on trial here for a little bit as we get set. That's what I get. I know it's my own fault. Why do I have this? The symbiote is just.
In the order that restrains you from talking to cats.
It's hot on this mic. No, it's not.
Hush.
Voice tone low.
I'm trying to have pork. Don't raise your voice.
Strength. Let's go to medium. There. I like that better. I like this better. It's quiet. It's a quieter mic. Works perfectly. All right. It only took like a year to fix that. All right. Anything else we need to talk about here? Is this going to be jury instructions being argued? Probably yes, and maybe some other legal matters as well. A member for 19 months. When and what is my next color? Next color, I believe, is going to be this pink color right here, and it's at 24. So you got a bit. It does slow down the further you go along, but you got a bit more.
Is that correct?
They need to argue kidnapping. I see some motion in the courtroom, so that's every time I look away, something happens. Seriously. Oh, it's the lady with the hair. I mean, they all have hair, and she, upon hearing me do that, she just played with her hair. Your door, any updates? I've reached out to a buddy of mine who does windows and doors, and I've said, can you please get us a deal on some tempered glass, because it's spendy. So we're going to try to get a bid on that today.
Okay, good afternoon. We are here outside the presence of the jury. The jury has been dismissed for the day to review jury instructions. Attorney Kennedy, before lunch, before we broke, you did make a motion. Would you like to state that further on the record?
Yes, Your Honor, just briefly, thank you. I'm moving to dismiss all 4 charges for insufficiency of the evidence. Even when viewing the evidence in a light most favorable to the state, no rational trier of fact could find beyond a reasonable doubt that the state's presented sufficient evidence to overcome their burden of disproving defense of others with respect to all the charges. Specifically, and I'm looking at paragraph 2 of physical force in defense of a person, 627:4, subparagraphs B, C, and D. We concede that A is not applicable, but B, C, and D, based on the evidence presented, are all applicable. Specifically, a person is justified in using deadly force upon another person when he reasonably believes that such other person, B, is likely to use any unlawful force against a person present while committing or attempting to commit a burglary. And that would be the evidence here that Caitlin was restraining Ellen, using unlawful force against her, and not leaving the home
while remaining
when
in the home.
Justin was telling her to, because her purpose was either to kidnap the child, interfere with custody and bring her across state lines, commit theft by extortion, or theft by deception.
She can't interfere with custody. She has custody.
And that would be the facts related to her coming to the apartments, overstaying her welcome, demanding money, making threats that she's going to take the kids and never, and Dustin will never see them again. Excuse me. C is committing or about to commit a kidnapping. Again, with all those facts that we have alleged through the state and through Mr. Duren's testimony, that her behavior and her comments show that she was about to or intending to commit a kidnapping. And D is likely to use any unlawful force in the commission of a felony against the actor within such actor's dwelling or its curtilage. And I don't believe I misstated this earlier, Your Honor. I would argue that I got it right, that the unlawful force is Caitlin using unlawful force against Elwyn while committing a felony against Dustin within Dustin's home. And that felony being any of the ones that I enumerated already: interference with custody, kidnapping, theft by deception, theft by extortion. And so for all of those reasons, we have presented evidence the state has not overcome, and the court should dismiss all 4 charges.
Okay, thank you. Counsel?
Your Honor, I'll ask that this court deny the motion. I believe the court already did deny it. I'll ask it to make that record clear. I'm going to cite the State versus Perez. Does not yet have a formal citation. It's 2025 New Hampshire 6, dated February 7th, 2025. And in State versus Perez, the Supreme Court discusses the standard that applies in the sufficiency challenge at the close of the state's case and after the close of the defendant's case as well, when the defendant has presented evidence. The court says that evidence presented in a defendant's case in chief could tend to disprove or discredit the evidence introduced by the state. Nonetheless, this type of evidence is immaterial to the trial court's analysis, because the trial court must view all of the evidence and all reasonable inferences from it in the light most favorable to the state. Consequently, the trial must construe conflicts between the state's evidence and the defendant's evidence in the state's favor when it's analyzing the sufficiency of the evidence challenge. Accordingly, the trial court's analysis of whether the state introduced sufficient evidence to prove the defendant's guilt would be the same regardless of whether it is conducted in response to a motion raised after the state rested its case or at the close of the evidence. I believe that is the controlling law here. With regard to the facts, again, the standard is in the light most favorable to the state, whether or not there is sufficient evidence for a juror to find in the state's favor. In this case, I won't try and properly state that double or triple negative that we discussed before, but there is certainly sufficient evidence for any rational trier of fact to find in the state's favor here. I think we strayed into a bit of a charge conference there with defense counsel's argument, but with regard to each of the different varieties of justified force in defense of a person, I think the state has certainly presented the necessary evidence for a rational juror to find that the defendant did not act in self-defense. I'll note for the court at this time, I'm sure we'll get into this more, but I'm going to quote from my notes here of what the defendant said during direct examination and his cross. Defense counsel just, I'm not sure why, but defense counsel just said that they don't believe they're going to make an argument about subsection A, where someone is about to use unlawful deadly force against the actor or a third person as a reason for justification. My notes indicate that that is exactly what the defendant testified to, and that's the only thing he testified to the exclusion of other reasons. The defendant said, again, these are my notes, so it's words to the effect of, he shot the victim because she hurt Elwyn. During the testimony about the multiple attempts to take Elwyn from the victim and take Elwyn from Caitlin, there was that third attempt that was unsuccessful, and at that point, according to the defendant today, a line was crossed. Elwyn was being physically hurt in front of me. My threat level went from orange to red. There was immediate danger and threat to Elwyn. I had to take action immediately to save Elwyn. I think the import of those is clear. The defendant told us that his entire mindset was saving Elwyn, and in conjunction with those other things, it is abundantly clear the defendant took the stand today and told us exactly what his purpose was in saving Elwyn. It had nothing to do with a burglary. It had nothing to do with extortion or theft by deception or any of these other things that Caitlin was supposedly doing while remaining unlawfully in his home. The state would not concede that she was remaining unlawfully. The defendant had not, I don't think, called the police and told her she needed to leave sufficient to have her trespassed. She was there with her child. So we wouldn't concede that she was remaining unlawfully, although the defendant certainly testified that he wanted her out of the apartment. With regard to kidnapping, again, I think we'll get into more of this at the charge conference, but the defendant testified that, yes, over the course of the day, he had these suspicions that maybe someone was outside in the car, there was someone, there were lights in the window, and he didn't know if Caitlin had brought anyone with her. But that was not his stated purpose in why he took the lethal action that he did. He was very specific and very clear that while these threats about money and other things are being made, after that third attempt, in his own testimony, a line had been crossed. He went from orange to red. Elwyn was being hurt. I shot Caitlin to save Elwyn because Elwyn was being hurt. That is self-defense or defense of another in response to the use of deadly force. That's 627.4.2a. That is not B, C, or D. I would disagree with counsel's interpretation of D. I think the wording of that is pretty clear, that it requires that the person who is using the deadly force believes that the other person is likely to use any unlawful force against the actor, not unlawful force against anyone while committing a felony against the actor. I think the other language in the statute makes it very clear where, even in B, the statute says is likely to use any unlawful force against a person present while committing or attempting to commit a burglary. D makes it very clear that the force is against the actor. It doesn't say against anyone in the home, or make it clear that the force can be used against anyone while the felony is against the actor. That doesn't make any sense. So for all those reasons, Judge, I think the motion to dismiss at this stage should be denied.
Okay, thank you. Anything further, Attorney Kenny?
Nothing, Your Honor.
Okay, once again, we're here. The first order of business relates to the motion to dismiss raised by the defendant previously before lunch. We will get to the charging conference and jury instructions, and I will explain what that is in just a second. But with respect to the defendant's motion to dismiss, the motion to dismiss is denied for the reasons articulated by the state. I would also reference State versus Perez as referenced by Attorney Spicer, and relating back to all of my arguments that were in the citations that were indicated at the close of the state's evidence, which was on Thursday, if my recollection is correct.
Yes.
Thursday? Okay, so I relate back to Thursday for purposes of the initial motion to dismiss, which was denied, and I would deny the defendant's motion to dismiss again at this time for the reasons stated previously and for the reasons stated by the state, not with respect to A through D, but at least with respect to the referencing of State versus Perez, 2025, New Hampshire 6. So motion to dismiss is denied. Excuse me. Now, with respect to jury instructions, for those who may not be familiar with this process, those other than counsel who may not be familiar with this process, sometimes this is referred to as a charging conference. The jury instruction process, what we're about to do, relates to the specific sentences and paragraphs that I am going to provide to the jury after closing arguments with respect to the law that applies to the case. This is the opportunity for counsel for both sides to describe and argue on behalf of their side what law should apply, what law I should give the jury as it relates to the instructions that are given to the jury. The jury instruction booklet that typically is used is a large 3-ring binder, and what we do in this process is we narrow that down to say what does the jury need to decide as part of this process. So it can be sometimes a lengthy conference, and that is why I sent the jury home for the day, so that we can have plenty of time to make sure that everyone has developed a sufficient record on both sides relative to the issues that we are about to discuss right now. Also, for the record, I previously gave the first half of my instructions to the jury before opening statements, and I'm going to come back to that in just a second. Next, I will state for the benefit of everyone that I did circulate a very rough draft of jury instructions to counsel at the end of the day on Friday, so that they would have the weekend to be able to review them and make their comments, be prepared to make their comments about what part of the jury instructions should be altered, what should be added, what should be taken away. And that's also what we're about to do right now. And there's one other thing I was going to say, but we can't finalize the jury instructions until we know exactly how the evidence has been completed. And now that the evidence has been completed, it gives the opportunity for everybody to make arguments about the appropriate way for me to instruct the jury at this point in the proceeding. So in terms of how we go through this, I know that we are going to take quite a few detours as is necessary as part of the process. But what I will indicate to counsel, I guess the first question I have is, in any case in which there is an extended period of time, read that to mean any case that lasts over a 3-day period, especially one that goes over a weekend. I guess the first question I have for counsel is whether or not there is a preference that I go back and read the first half of my instructions again, instead of just the second half of the instructions. I don't know if anybody has any position with respect to that. I have done it before where there's been a request that I go back and read all of the instructions from the beginning. Any comment on that, Attorney Duren or Spicer?
The state doesn't feel strongly about it, Your Honor, but I do think that out of an abundance of caution with the case of this gravity and with the length of time that has elapsed since the originals for the first instructions were given,
seriously,
it would make sense to deliver those again. Because I think there are a number of topics in there that
we're on day 5.
Valuable to deliver to them again with regard to the credibility of witnesses, that sort of thing.
Okay, all right. Counsel?
No position, Your Honor.
No position? Okay. All right. Based on that, and I want to state in that regard that one of the dangers in doing that, of course, is that if they are going to place special emphasis on the part that they heard before, however, I think that risk is mitigated by virtue of the fact that it does contain, there's typical language in there that says, please do not single out any instruction for any special emphasis. So the fact that they're hearing a portion of it a second time, that risk is mitigated or ameliorated by virtue of the fact that there's a separate instruction saying, please do not place special emphasis on any one instruction. So defendant has taken no position. State thinks in an abundance of caution, and the court agrees with the state. I will read the entire amount of the jury instructions from scratch. I realize that they are lengthy. However, I do think in this case it is important. It just dawned on me what I forgot to say to those who have not been through this process before. So I'm taking one step back. The other reason why we do this, of course, is because counsel, experienced and competent counsel on both sides, want to be able to frame their closing arguments based upon the law that I'm going to give to the jury. So in other words, when they prepare their closing arguments, it is of great benefit and necessary for them to know what the law is going to be, how I'm going to instruct the jury, so that they can tailor their closing arguments to the instructions that I'm going to give. So closing arguments will come first, jury instructions second, but we're talking about the jury instructions now so that the closing arguments for both sides can appropriately be tailored to fit those instructions that they're going to hear after the closing arguments. So once again, that is why we're having this particular conference at this time. Okay, next order of business with respect to the draft that I circulated. First, the copy I circulated should have page 10. Any issue with respect to page 10, counsel? Okay, on to page 11. So now with page 11, I guess the first question becomes, and my question will go to the state, the way I've structured this, the way I've structured it, once I get to the bottom of page 11, would be to include the elements there. What the defendant has proposed as part of their instructions is to include the self-defense element as directly as part of those elements in the first recitation of the elements for the second-degree murder knowing charge. State's position with respect to the defendant's structural argument to place the defense of others element into page 11 and 12. Attorney Spicer.
Your Honor, just to be clear, are you referring to including the defendant did not act in self-defense as an element? Or are you referring to including the larger body of self-defense instructions at this point?
And that's whether we say self-defense or whether we say defense of another. do I include that element, assuming that I give it, which I know we're going to argue about here in a second, but is that structurally, do you have an objection to structurally me putting it in there, not relative to factual support, but relative to the structural component, the architecture of the instruction, so to speak?
And again, Judge, just so I'm clear, when you refer to the architecture, are you referring to the greater amount of instructions on self-defense generally, and whatever versions that you might find appropriate, or are you referring to adding an element to each charge?
Do I understand your question completely? Do I adopt what Attorney Kinney proposed?
Well, I'll address both.
Yeah.
In my experience, I think there's no wrong way to do it. I do think it makes more sense logically and structurally to get into the elements of the offense first and then self-defense afterwards. So here's what the elements of secondary murder knowing are, reckless in each charge, and then self-defense afterwards. That mirrors, I think, the way the case comes in with the state's case and then the defense's case. I don't have any case law, for Your Honor, on whether or not there's a right way to do that. So I guess the state's position is that if it were up to us, we would propose charges first, or elements of each charge and each offense first, and then self-defense afterwards. With regard to whether or not there should be, second-degree murder, the elements are cause of death for another, do so knowingly, and then number 3, not acting self-defense, if the court finds that's appropriate. I think the case law says that there's either way is appropriate. There's case law that makes very clear that a court's choosing to instruct just on the elements of each offense and then instruct generally on self-defense and make clear during that general instruction that self-defense instruction applies to all charges. That is satisfactory. That is not erroneous or in any way legally problematic. I know it's been done both ways. Adding an element is not legally incorrect. So I think the state was satisfied with the structure that Your Honor had in the rough draft. I don't think defense's interpretation on that, either of those two topics, is wrong.
Okay.
That's what I would say.
Okay.
Judge, I think the case law, while it says it's not reversible error not to add as an element, the case law is clear that the court should add as an element. So I'm going to read from State versus DuPont, 165, New Hampshire 698. And DuPont references the framework outlined in State versus Soto, 162, New Hampshire 708. So in DuPont, they say, here then, it is enough to say that when the defendant is entitled to a specific instruction on both provocation and self-defense, which I understand that's not necessarily where we are here, trial courts should add disproving self-defense as an additional element of the offense that the state must prove beyond a reasonable doubt. So I think that the Supreme Court has indicated a clear preference. I think the reason for that is that it is the clearest and fairest way to instruct the jury. I think it becomes much more confusing to address self-defense kind of abstractly separately from the elements of the charged offense. The law is clear that when there is some evidence of self-defense or defense of others submitted, the failure to act in self-defense becomes an element the state must prove. And so the court should instruct that it is an element the state must prove in accordance with the settled law in State versus DuPont.
Okay. All right. Thank you. Anything further?
No.
Okay. All right. And so let's go right there, Attorney Kettles, with respect to, let's assume that I'm going to grant your structural argument as it relates to where the elements apply. Okay. Sure. Let's assume that I'm going to grant that where it should apply. So tell me, with respect to second-degree murder, knowing how you want the proposal. Let me find it that I've received from you or from Attorney Kinney. The one that I received indicated that the defendant did not act in defense of another.
Yes, Judge, and so just to make it clear, we did essentially start at the bottom of page 11 and submit an entire version on Sunday, which I trust the court received. Which
I have, B, which I thank you for, and I'm following right along.
Thank you. And so it should say the defendant is charged with a crime of second-degree murder. The definition of this offense has 3 parts or elements. And then I think we track your language, except that we then add a 3rd element, and the defendant did not act in defense of another. Then there's the knowing instruction, which I believe is the same, And then, Judge, on page 2, 3, and the top of 4, we provide our proposed instruction on self-defense, and I can read it into the record, but I don't think it's necessary as we've submitted. I'm sorry, it's defense of others.
Yes.
When I say self-defense, Judge, please just assume I mean defense of others. I think it just makes the matter clearer to the jury if we use the phrase defense of others rather than self-defense, since we're not, at this point, we're not arguing that Mr. Duren acted in defense of himself, but rather he acted in defense of Ellen.
Okay.
And so we ask that the court adopt our proposed language on self-defense, which, or defense of others, which tracks the statute and I think accurately states the law.
And I know why you're rising, Attorney Schweischer, and we will please make an outline as I am, so that we can go through each thing step by step. I know why you're rising. I don't want to interrupt Attorney Kettles further at this point.
And Judge, I'll note for the record that our proposed instruction tracks the instruction that was given in another case in this court, State versus Nomar Ramos Rivera, docket 214-2023 CR 26. It also, I believe, tracks instructions that this court has given in, what was your case?
Green.
State v. Hunter Green. And then another case that Attorney Harding told me about but didn't tell me the name of. So I'm sorry that that's not very helpful, but
Koval.
Perhaps the court remembers.
Koval.
Yes, and so I think it's the instruction that the court has used before, both you, Judge, and the prior judge who sat here. It's an instruction that's based largely, I think, on the language that the Attorney General's office uses when discussing use of deadly force by police officers. The standard is the same for people who are not police officers. They should be entitled to the same instruction. It's a correct statement of law.
And Attorney Kettles, just to follow along, I think it was just a typo, but with respect to the submission, I assume that on top of page 2 that once again you're for defense.
Yes, Judge. Anywhere I'm using self-defense, please make that mean defense of others.
Certainly. Okay.
And I don't think the headings are read to the jurors, so
They are not, but they do get copies of these.
that's true, Your Honor.
So.
I apologize.
Okay. Okay. Okay, once again, assuming for purposes of this discussion that I will be altering the structure to be that which was requested by the defense, Attorney Schweischer. With respect to the entitlement of the defendant based upon the facts relative to any of the defenses.
Thank you, Your Honor.
Any of the pure defenses, I should say.
First, just as to the characterization of we're only dealing with defense of another, I think defense counsel argued earlier with regard to burglary under 627-24C that their theory was that the defendant actually and reasonably believed that under their interpretation, Ms. Napster was going to use unlawful force against him, or use unlawful force against Ellen in the commission of a felony against him. I think that does bring us back into self-defense rather than purely defense of another if there's a felony being committed against him. So that's just a characterizational note.
And can I stop for a second? Sure. So with respect to 627-4, 2A, and referencing the argument that you made during the motion to dismiss, I would just point out that A says is about to use unlawful deadly force against the actor or a third person. You've referenced Mr. Duren's testimony as it relates to the perception of force being used by Ms. Nafziger against Elwin. However, you would agree that he was not perceiving deadly force against her.
I agree.
Okay, I just want to make sure.
So with regard to what instructions the defense is entitled to at this point, the
yes.
state's position is that the defendant is entitled to an instruction on 627-4-2A based on his testimony. And again, the import of his testimony So first, Your Honor, I'll try to structure this. With regard to B, C, and D in 627-4, those subsections, the state believes that the defendant has not shown, and there is no evidence sufficient to meet even the low bar for a jury instruction, I believe the standard is some modicum or more than a mere iota. I don't have a case site, but I believe
Scintilla.
More than a mere scintilla, yes. That is
my favorite
my
word.
understanding of the standard. The defendant took the stand and told us exactly what his mindset was. He used those phrases that I quoted, and again, those are from my notes, but he said, in response to a question on cross-examination, he agreed that he shot the victim because she hurt Ellen. And that is the import of all of his statements. While the defendant certainly testified that over the course of that day, leading up to the murder, he had in his mind some suspicions about things that were going on, and that Ms. Nafziger was making threats against him and asking him for money and telling him that if he did not provide her with money or did not sell his car, she would do certain things or call the police or take his children away from him. His testimony is very clear that when it came to the point that he is trying to get everyone into the car so he can drive them all back to Hampton, he is attempting to remove Ellen from Ms. Nafziger's arms. She refuses. There are multiple attempts, and after the third attempt, he told the court and the jury that the line was crossed, Ellen was being physically hurt in front of me, the threat level went from orange to red, and I perceived an immediate danger or threat to Ellen, and I had to take action immediately to save Ellen. That is why he acted. He did not act, I think it is clear, by omission in his testimony. He did not act because he believed that Caitlin was in the process of, was committing or about to commit a burglary by committing any other crime while remaining unlawfully in his home. I think that is imputing an intent to Ms. Nafziger that is not present. We don't have any specific testimony or evidence about whether or not Ms. Nafziger remained unlawfully in the home with the purpose to commit a burglary by committing any predicate crime. But I certainly don't think that that standard has been satisfied for purposes of a jury instruction, particularly in light of the defendant's testimony. With regard to C, kidnapping, I know that there's been a lot of litigation about this, but while the defendant said today that he believed, or that there was some suspicion in his mind that Ms. Nafziger was going to kidnap the children, that's not what he told the police in his statement. And it's also not what he said today about why he actually committed the killing, why he pulled the trigger. Yes, he had these suspicions, but he called them really just suspicions. In that vein, Your Honor, I think the state of the evidence, as according to the defendant, is important to take into account here. At the time the defendant pulled the trigger, by his own account, Ms. Nafziger was sitting on the couch. The crime scene photos tell us that she had one foot up on the table. She was not wearing any shoes. The defendant, by his own admission, was between her and any knives that were in the apartment. He was between her and the doorways. She could not exit without going through him. She was unarmed. She had not threatened to hurt him or to hurt Ellen or to hurt Ayden. Given all of those things, and what I have referenced multiple times now about the defendant telling us what his entire mindset was, there's no evidence that he killed Ms. Nafziger because he actually or reasonably believed that she was committing or about to commit a kidnapping. The moment in time that matters here is the time that he pulls the trigger. And at that moment, for him to merit a jury instruction on kidnapping and self-defense, he had to actually believe that she was committing or about to commit a kidnapping, and that belief has to be reasonable. And that's not what his testimony was, and it's not reasonable. There's not even a mere scintilla of evidence that would support that that's a reasonable belief if he held it. And his own testimony here today has told us that he did not. I think the same argument applies to subsection D about whether or not the defendant actually and reasonably believed that Ms. Nafziger was going to use any unlawful force in the commission of a felony against anyone, him or Ellen, however that statute is construed. The defendant's testimony today and his statement to the police was that Ellen was not, the victim did not threaten to harm anyone. For him to say now, at this stage, that he actually and reasonably believed that there was a likelihood that Ms. Nafziger was going to use unlawful force against either himself or Elowen is just not supported by the evidence, particularly in the commission of whatever felony. The defendants claim that he believed that there was this kidnapping or that there was interference with custody going on. This other crime that I think will become relevant in a minute, I think is also not supported by the evidence, where for Ms. Nafziger to kidnap her own children, to commit the crime of interference with custody by taking them away or concealing them from the defendant would require her to leave. It would require her to do something other than remain in his apartment holding the child. And there's no evidence that she did anything of that nature. And again, she had no car, she had no bus ticket, no family or friends close by. She was not wearing shoes, she was not dressed for the weather. The defendant's own testimony was that he shot her and he pulled the trigger because she refused to let go of her child. That is not her committing or about to commit a kidnapping. She's not running out the door into a waiting car. She's not taking Elowen and Valen and hopping onto a bus when the defendant's not looking. That's simply not what the testimony is. I'll reference the degree of force jury instruction here as well. The court included it properly in the rough draft. I think it should be there. Obviously, as it should in every case involving self-defense and deadly force. There is no evidence that the defendant actually, or reasonably believed, that he used only the right amount of force necessary to commit, to act in his own defense. Whether he's doing it to defend Elowen or himself, to defend a kidnapping or otherwise. Ms. Nafziger was wearing no shoes with one foot on the table. She weighs half of what the defendant weighs, or roughly half. She's significantly smaller. The defendant testified that he is a trained Marine. He's been through boot camp, he's been through infantry training, he has this martial arts training that allows him to disarm anyone. His own testimony was that Ms. Nafziger was holding Elowen, although there's a dispute over this. According to the defendant, in the light most favorable to him, Ms. Nafziger was squeezing Elowen, perhaps enough to make her shriek. We don't accept that that's what the evidence is or what the evidence shows or what actually happened, but that was the defendant's testimony to some effect. By his own admission, Ms. Nafziger was not armed. She did not have access to a deadly weapon at the time that he pulled the trigger because he had the only gun in the apartment. And he said the only knives in the apartment were behind him, some distance away. They were certainly not readily close at hand. He didn't say that. They don't appear anywhere in the crime scene photos. The defendant shot Ms. Nafziger in the head. He is, by his own admission, an expert marksman. He has trained hundreds or thousands of Marines on how to shoot their weapons and how to use those to hit their target and eliminate threats. He testified he didn't shoot Ms. Nafziger in the arm. He didn't shoot her in the leg. He shot her in the head because that was his purpose. He told us today that he absolutely did aim when he fired his gun. So I think the import is very clear. It was his clear intent that he executed to shoot Ms. Nafziger through the side of the head where her hair was covering the side of her head. That is not proportional, and there's no evidence that was only the degree of force that was necessary. There's no evidence that any rational juror or trier of fact could find that. So I don't think the defendant has met the bar or satisfied their burden to obtain a jury instruction on self-defense under any of these varieties. While I am making this rather lengthy argument, Judge, I'll just state, I think, to wrap up, if the court is inclined to give an instruction on self-defense in the kidnapping version, it should be specific and it should include a definition of what kidnapping is. The defense has not supplied a definition of what kidnapping is, although they argue that it is not the definition that's contained in 633.1. I think they have rather pointedly not defined it. And I don't think it is appropriate for this court to leave that open-ended and essentially allow the defendant to define his own version of self-defense in the kidnapping version. If the court is inclined to give a self-defense instruction relative to kidnapping in 627.4, 2C, we think that the court should instruct the jury what kidnapping is and what it is not. That kidnapping is, and I think we'll reference the statutory definition, a person commits the crime of kidnapping if the person confines another under their control, the person does so knowingly and acted with a purpose to hold the person for ransom or as a hostage, avoid apprehension by a law enforcement official, terrorize the person confined or some other person, or commit an offense against the person confined. And again, it's our position that the defendant has not satisfied any of these, given the testimony and the state of the evidence. If the court does instruct on the kidnapping self-defense variety, we also think the court should make clear what kidnapping is not, and that relates to interference with custody and 633(1)(a). The court has the legislature has specifically laid out what kidnapping is and what it is not in terms of a parent and their child who is related by blood. It cannot be the case that the defendant can receive the benefit of a kidnapping jury instruction for behavior consistent with 633(1)(a) when the legislature has said that is not kidnapping in this situation as it applies to him or to Ms. Nafziger. He certainly can't obtain the benefit of that when the law clearly says that he is not entitled to it. And I think it's important that the jury know that to prevent some sort of issue with specific unanimity or failure to agree on a specific definition of what kidnapping is. I think I'll stop there.
Once again, thank you, Attorney Special. Once again, with respect to 627.4(2)(a), I think that there was one point where you argued that the defendant was entitled to that instruction in one place where... I
misspoke, Your Honor. I think that's what the defendant testified regarding, but given the degree of force issue and the proportionality of force and the state of the evidence with regard to that, I don't think he's entitled to that or any other.
So the reason the reason why 627.4(2)(a) would not apply relates to the amount of force.
Correct. Bringing a gun to a fist fight, so to speak.
Understood. Okay. Understood. All right. So from my perspective, and we'll get further relative to the kidnapping issue in a second, but Attorney Kettles, with respect to, I don't think there's any issue with respect to A, correct?
That's correct, Judge.
So
we're arguing that
B through D?
Yes, B through D.
Okay.
And Judge, the state has pulled a single piece of evidence out of context to rely on, but I think the overall comport of the evidence is clear. And I'll quote what Mr. Duren said both on cross and on redirect. The goal was to eliminate a threat who was holding my child hostage in front of me and hurting her. That alone is enough to get defense of others instruction under D through E, but that's not the limit of the evidence. That's not the only evidence in support of the defense of others instruction. And Judge, I think most of the other arguments that the state has made has gone to their perspective on the strength of the defense, not on whether or not the sum evidence standard was met. The sum evidence standard has been met. The court stated that it had been met at the close of the state's case, and since then, even more evidence of defense of others has been presented. State versus Brooks and State versus Woodburn and many other cases cite the same standards. And for the record, Brooks is 2025 New Hampshire 12, and Woodburn is 175 New Hampshire 645. The standard is, quote, for there to be some evidence to support a defendant's specific defense, there must be more than a minutia or scintilla of evidence. The evidentiary support need not be overwhelming. State versus Brooks further explains, quote, when a defendant asserts a pure defense and there is evidence to support the defense, negating such a defense becomes an element of the offense that the state must prove beyond a reasonable doubt. We have held that an erroneous jury instruction relieving the state of its burden to prove an element of the charged offense constitutes structural error, and that structural errors require automatic reversal of a defendant's conviction, end quote. And again, State versus Brooks, when there is some evidence to support a pure defense, a trial court's failure to give a jury instruction on that defense is akin to failing to instruct on an element of the offense. And we have far more than a minutia or a scintilla of evidence here. That one quote, the goal was to eliminate a threat who was holding my child hostage in front of me and hurting her, is some evidence. The additional evidence, and I'm not going to go over it.
The jury doesn't believe she was a threat.
Here. There's evidence that Caitlin actually had a plan to take the children out of the state without telling Dustin. There's evidence that Caitlin bear-hugged, restrained, and confined Elowen and would not let her go. There is evidence, and by evidence, Judge, I mean not only Mr. Duren's testimony today, but also the evidence that the state presented through its recorded interview, as well as Ms. Palmunden's testimony. While restraining Elwyn, Caitlin threatened to call the police and lie to them and say that Dustin had kidnapped Elwyn unless Dustin gave her money. Today he testified it was a significant amount of money. I believe the police interview talks about $2,000 a month. Today he testified about her telling him to sell his car, which is certainly worth over $1,000. And so there we've got not only the kidnapping and the unlawful interference with custody, but that's also where some evidence comes in that she remained. This is after he told her to leave over and over again and said, "We're going, I'm putting him in the car, we're going." And she still sat there and she made these threats. Judge, that's burglary. That's purpose to remain in the home with the purpose to commit theft by deception, lying to the police, saying that he kidnapped Elwyn in order to get money, theft by extortion. If you don't give me money, I'm going to take your kids away and you'll never see them again. That is felony level unlawful interference with custody, trying to take the kids out of the state. It's a felony against Mr. Duren, and it's also burglary, purpose to remain in the home with a purpose to commit stalking, harassment, and a number of other offenses. An additional piece of evidence: while restraining Elwyn, Caitlin said Dustin would never see his children again, that she was going to take them from him. Another piece of evidence, some evidence in support of this instruction: Caitlin pulled and yanked back on Elwyn forcefully enough for her to scream in pain. I think the evidence has been clear that Dustin shot Caitlin because she was doing these things. He has described this entire situation as being very intense, very chaotic. All of this stuff kind of building up to the moment when the line had been crossed, right, where his goal was to eliminate the threat, who was holding his child hostage, and who was hurting her. The fact that that's the moment at which he acts doesn't mean he's not acting because of all the other stuff that's happening. He's acting because of everything in combination, and that's the moment at which he can no longer just do this tug of war, right? He has to take further action, proportional action, because of the pain that's caused to the child. That doesn't mean he's not acting for these other reasons. And I think the testimony has also been that Dustin shot Caitlin while she was still holding Elwyn. So while she was still restraining her, holding her hostage, about to commit a kidnapping, committing a burglary with the purpose to commit all of these other crimes, and using unlawful force while doing so. Dustin's belief was reasonable. It was correct. She had a plan to kidnap the kids. His belief that she was going to do so was reasonable. And Judge, I think I've cited unlawful interference with custody, false imprisonment, false report to law enforcement, two other crimes that she remained in the home with the purpose to commit.
If I grant you 627.42B, do I have to then define burglary?
Judge,
And how long is that going to take?
How long is it going to take?
Not with respect to the argument, but with respect to the instructions.
Yes, I think that, so, from a kidnapping perspective, the case law was supported in our memo, or cited in our memo, State versus McDonald, which I've referenced at prior hearings, which is 163 New Hampshire 115, make it clear that the court cannot limit what kidnapping is to the statutory definition, but it's something broader. I think that the court could instruct on burglary and on all of these different offenses, and that would correctly state the law to the jury if they added in that the state must prove beyond a reasonable doubt that he was not acting because he reasonably believed that she was about to commit a kidnapping, and the state must prove beyond a reasonable doubt that he did not reasonably believe that Ms. Napster was likely to use any unlawful force against a person present while committing or attempting to commit a burglary. I think the court could then provide a series of examples of the purpose to remaining in the home with a purpose to commit a crime, and could provide a series of examples of what those crimes might be.
I mean, McDonald talks about the phrase forcible sex offense, which is not coextensive with aggravated felonious sexual assault.
Yes. And it said there, I think McDonald and the other cases that I cite in my memo make it clear that unless it says as defined in the statute, it's improper for the court to limit what the word means to the statutory definition.
So, by providing examples, aren't I in a way limiting?
No, I think the court could provide examples and then say, or any other type of burglary.
But that's a large list.
Yes.
Okay.
But
All
I
right.
think correctly instructing on the law may require a large list, Judge.
Okay, please continue. Thank you.
Yes, Judge. And the state is trying to argue essentially different interpretations of the evidence, maybe asserting that there is contradictory evidence, but that doesn't change the fact that the court must give the instruction. State versus Kavanaugh is a case we haven't discussed much yet, but it's 174 New Hampshire 1, a 2020 case. And the Kavanaugh was abrogated by Brooks to the extent that Brooks said, look, this is structural error. But the rest of Kavanaugh is still good law. And there it says, quote, to be entitled to the instruction, the defendant had only to demonstrate that there was some evidence to support it. She did not need to submit proof beyond a reasonable doubt that she acted in self-defense. And it said also, the defendant contends that the trial court unsustainably exercised its discretion because it decided the merits of her self-defense claim instead of determining whether there was more than a scintilla of evidence to support it. We agree. Although the evidence was conflicting, we conclude that there was more than a scintilla to support the defendant's assertion that she acted in self-defense. What the court's asking you to do is basically to decide, or the state's asking you to do, is basically to decide the merits of the claim rather than allowing the jury to do so as it's proper. State versus Woodburn, it's got some interesting language in it about how the jury can make various inferences about mental state, even if the defendant doesn't testify specifically about mental state, that I think are instructive here, but I'll also note that State versus Woodburn says, to the extent that testimony can be construed as contradicting other testimony supporting the self-defense instruction, any inconsistency was for the jury to reconcile, not the trial court. And the sum evidence standard does not require that the evidence presented by the defendant be uncontradicted. So, Judge, I think we've got far more than a minutiae or scintilla of evidence here for the subsections of 627.4 B through D. And so the court must instruct the jury on defense of others.
Okay, with respect to C, my question, Attorney Kettles, with respect to C relates to NUCAS, N-O-U-C-A-S, at 165-146. And the issue relates to the kidnapping issue, which is, I just want to make sure I understand the defendant's position. In NUCAS, it appears that Judge O'Neill denied the instruction based upon, my phrase is that it wasn't a question of whether there was sufficient evidence, and it wasn't a question of the court making a credibility determination based upon the evidence. Instead, Judge O'Neill was affirmed when he refused to give the instruction in NUCAS because it didn't have the legal predicate for it. And I guess that's why now we're getting to the point of why I asked for the memorandum in the first place as it relates to the kidnapping issue, and specifically the 633-1A, if I'm doing this from memory, relative to the question relates to NUCAS, and it relates to legally, not factually, but legally, is the instruction to be given based upon the specific facts at issue here. And I'm asking you that question, and I'll go back to the state with respect to their position as it relates to how this situation relates to the NUCAS situation. Excuse me.
And Judge, let me make sure I understand. My recollection of NUCAS is that it deals with a situation in which the defendant is presenting a theory of the case rather than a theory of defense. So in NUCAS... No?
Not by my read. My read, excuse me, my read is that it was a theory of defense. However, the predicate in order to trigger the defense wasn't met. I believe the word any is italicized in NUCAS at the relevant. I can get the pin site, but that in this case there wasn't any evidence that justified the theory of defense. And I could be wrong about that, but I think that's the number one thing I've been looking at. Are you factually, is the defendant entitled from a legal standpoint, not from a factual standpoint? But once again, continue.
Judge, I'm not sure. I need to reread NUCAS, but my notes on it indicate that in that case the
Hey, Barb, I'm trying to focus on this one, so I don't know.
He testified to different versions of events than the state alleged, and the defense of others would have been in regards to an offense he wasn't charged with. So he wasn't saying, like, I think in NUCAS, let me just make sure I'm right. he was convicted for accomplice to armed robbery. And he essentially argued, I'm not going to get the exact facts right here, Judge, but he essentially argued, I was justified when I assaulted someone. And the court said, well, you're not charged with assault, so it doesn't really matter. It might not be assault, that's an example I'm using. It doesn't really matter whether you were justified in assaulting because that's not what you're charged with. Your being accomplice to armed robbery has nothing to do with defense of others. And so here, you know, he is admitting to committing the act, and he is saying that the act was justified. And so nucus is not applicable because the defense of others resulted in the charged offense.
Okay.
If defense wins this argument here, I can see a slippery slope that will lead the jury to acquit.
Sorry to make you get up again, Attorney Kettles. Once again, with respect to B through D, under McDonald, you're asking me to use the expressions with respect to B through D from a colloquial sense as opposed to a strict sense?
Yes, Judge, as it relates to kidnapping, we're saying that cannot properly be limited to the elements in 633.1. And I want to be clear, in case there's any dispute, I'm not saying 633.1A applies. I know what the word consanguinity means, but the court would be improper to limit the jury to considering the elements of 633.1.
But you're looking for a colloquial definition as it relates to kidnapping and to burglary?
I don't think that there needs to be a definition of the word kidnapping in State versus McDonald. There was no definition of the word forcible sex offense.
Correct, but they're using it in terms of I think they used a colloquial, the way in which it's defined.
What?
As opposed to a statutory definition. I could be off on the word colloquial.
It's a hard word. I don't think I can spell it. Colloquial.
Judge, my understanding is that the court just included the phrase forcible sex offense and explained our statute is clear, the language is not difficult for the jury to understand in McDonald.
Okay. All right. Thank you. Okay. State's position based on that?
Your Honor, I think I'll refer to State versus Davidson, which was cited by the defense and the state, 163, New Hampshire 462. In that case, the Supreme Court interpreted RSA 627.8 relating to use of force in defense of property. And there, they were concerned with the term unlawful taking, and they ruled that it is not limited to merely theft, quote unquote, as defined by statute. But the import of that is that it was not limited to theft because the term unlawful taking can include other behavior besides the statutory definition of theft, similar to forcible sex offenses, which can include a variety of different offenses. Kidnapping is not one of those. So what the court is saying in these cases is that we're not saying as defined by, because we are talking about a larger category of statutorily defined offenses. In Davidson, they made it quite clear that we're talking about the top of a funnel here, not the bottom of it. And so in this case, 627.42C specifically references kidnapping. 627.42B references burglary. Those are specific words relating to specific crimes that are defined by statute. I don't think it is appropriate, the state does not believe that it is appropriate to leave open the definition of those terms to a colloquial definition, which is inviting the possibility that the jury is going to make a decision on an incorrect definition of those terms. I think that's simply not appropriate, particularly in light of the situation. We're not talking about defining these offenses for purposes of a charge of kidnapping or a charge of burglary. We are talking about doing it in relation to the use of deadly force and whether or not that deadly force is justified. And as we make clear in our pleading, I think it's very clear and not arguable that the use of deadly force in self-defense is only available in certain prescribed circumstances, in a very narrow set of circumstances as defined by the legislature. What the defense is asking is to blow that up and allow the defendant essentially to define or leave open for the jury to sort of just on their own define in a colloquial sense, what does kidnapping mean, what does burglary mean. In a situation like this where deadly force is involved, the court should make sure that the jury knows what those terms mean and that they are agreeing on what those terms mean, whatever their verdict might be.
And Judge, the state's argument would ask the court to include language the legislature did not see fit to include, and would ignore the clear guidance in State versus Woodbury 172, New Hampshire 358. And the guidance in Woodbury says that when a statute includes the phrase as defined in RSA X, it is a term of art. But when the statute does not include the phrase as defined in, it is not. And so if the legislature wanted to, it could have made a statute that says a person is justified in using deadly force if he reasonably believes that a person is committing or about to commit a kidnapping as defined in RSA 633(1). We know that the legislature knows how to do that because it does so in a number of other statutes, including the one outlined in Woodbury, including 627(8), and a number of other statutes that I referenced before, the reckless conduct statute, and other portions of the justification statute. The legislature knows how to make something a term of art by saying as defined in a statute, and it chose not to do so here.
Okay.
Seems like this should have been hammered out long before right now, but
you want to go to the I've got my thoughts on that, but we'll keep going right now. Let's go to the defense's request relative to use what in this geographic part of the state is colloquially referred to as the NOMAR instruction relative to self-defense. What's been proposed by defendants relative to the NOMAR instruction. The state has proposed the self-defense as it relating to the 2011 criminal jury instructions. Am I correct? 85 or 2.
Proposed anything, I think. I don't know if that's what the court used.
You did propose.
We did.
Yes, back in September.
Oh, yes, I apologize. Yes.
Not recently, but back in the September filings.
Yeah, I think we referred back to the model instructions. Again, I don't think that those instructions from NOMAR are wrong, but I think different courts and different situations can instruct differently, but I think that the instructions in the court's rough draft are appropriate and track the law, track the model instructions with no deviations. I think obviously the instruction that's proposed by the defense are more favorable to the defense, so in that sense we don't believe that the court should give them, but I think either is appropriate.
Okay, thank you.
All right, what's next?
And Judge, again, they're not wrong, right? The NOMAR instruction is a joint statement of the law. I'll note that the model criminal jury instructions were actually drafted in 2010, and the defense of other statute has been amended since then. And so I think that in and of itself is a reason to give the NOMAR instructions rather than one that a draft instruction not finalized that predates the most recent version of the statute.
Attorney Kettles, if I give the NOMAR instruction, so to speak, what's your position relative to the request from the state to use the degree of force instruction from Etienne?
Oh, I like this one.
Judge, I would argue that I have a couple of arguments about Etienne. The first one is that, again, at least the case itself predates the amendment to the defense of other statute, and therefore the court there didn't consider the amendment to the defense of other statute. I also think it's important to note that Etienne is discussing a case where a person is, where the claim is that someone is about to use unlawful deadly force against the actor or third person. So there's this kind of built-in proportionality that needs to happen there, right? It needs to be deadly force.
Yeah, and this was not deadly force.
Deadly force. A slap in the face cannot be met with deadly force.
A tight hug
but by
cannot
contrast,
be met with deadly force.
The other three kind of subsections of the statute are things where the legislature has determined if this happens, it's okay to use deadly force. If there's a kidnapping, deadly force is proportionate. If there's a forcible sex offense, deadly force is proportionate, right? This is very different, this subsection, than the rest. There's no requirement that any force be used at all. And so I don't think that there can be a proportionality assessment when there's no requirement that any force be used at all for the defendant's actions to be justified under the law. And I think that kind of recognizes the split-second decision that someone needs to make when one of these serious, they reasonably believe that one of these serious offenses is about to occur.
Okay. Want to proceed to the other two elements? Excuse me, the other two crimes, Attorney Spicer?
If I may just touch on the degree of force, Your Honor.
Certainly.
I certainly don't think it was the legislature's intent to allow the use of deadly force where there is no force used or no degree of deadly force used in any of these other contexts besides the one in 627-4A. In the defense's reading of this, under B, there's a burglary. If I remain in someone's home unlawfully or enter by going into someone's apartment and I tell that person, I'm going to steal your wallet. According to the defense's interpretation of that, if I don't touch them, I don't brandish a weapon, I don't wave a knife in their face, if I just say, I'm staying here, I'm not leaving, and I'm going to take your wallet, they can shoot me in the head. I don't think that comports with the law. There's significant case law on this. Etienne, most of all, State versus Mayo as well, 167, New Hampshire 443. Says a person can defend against what he reasonably believes to be the imminent use of unlawful, deadly, or non-deadly force by another, and can use the degree of force that he reasonably believes is necessary for this purpose. I think that's kind of built into the law there, so I'll address that and leave it there. Your Honor, I wanted to move on to what next? I apologize.
Is there anything else before we move on to reckless conduct in child endangerment? Anything else anyone wants to say for purposes of the record?
Both sides are trying to get their last jab in because the judge isn't giving any indication which way he's going to rule. So they're trying to add.
Okay.
Make sure
I want to make sure everybody's developed. Before I start making rulings on those, I just want to make sure everybody's got their factual record. Excuse me, their record relative to the arguments that have been made.
I think the one thing I would add, Your Honor, tapping onto the discussion of whether kidnapping should be left open as a colloquial definition. I think it's important for the court to instruct not only on what kidnapping is, but what it isn't, to avoid a situation where the jury, mistakenly or not, believes that the defendant was acting because he thought Ms. Nafziger was going to take his kids away and take them away to Minnesota, which would legally constitute interference with custody rather than kidnapping, because the children are related to both individuals by blood. Ms. Nafziger could not legally be charged with kidnapping for doing that. I don't think it's acceptable to run the risk that the jury, because of the testimony, mistakenly acts on that and acts on a mistaken understanding of what legal definitions apply here. So if the kidnapping instruction is given, our position is it should not only define what kidnapping is and that the defense should be held to which particular theory of kidnapping under the statute they believe the facts support, but also what kidnapping is not, so that there's no danger that the jury is making its decision on a mistaken interpretation of the law.
Okay.
Yeah, that's the good one.
Right now it's 2:10, and at some point we'll take a break.
Not yet.
And I guess one of the things I'm soliciting input on right now is, should I make some initial rulings right now and have folks proffer their requested instructions as the best use of our time as it relates to what we're doing right now before a break, before we get to the other two charges? If you understand what I'm saying.
I don't think there's a significant dispute for the other two charges, right? We would once again add that the element of defense of others should be added, but I think it perhaps makes sense to get through everything so that we can get the court's actual instructions.
Sure, I want to leave enough time so the council can assist with getting the instructions before 4 o'clock is what we're going to be doing here. I mean, let me make it clear. I'll work all night, but you won't have the benefit of that relative to your preparation of closing arguments.
However the court wants to handle it.
What's that?
However the court wants to proceed.
Let's go with the reckless. Let's go with second degree reckless. I want to hear argument about whether let's do second degree reckless, and then we'll take a break after that. I'll make some rulings, then we'll take a break. So I guess my question relates to the defendant version includes the defense requested version includes the phrase depraved heart, whereas the state's version, I believe, does not, based upon the jury instructions relative to the manifesting extreme indifference to human life. If I'm wrong about that from the state's perspective, let me know, but I believe that under the model jury instructions proposed by the state that the phrase depraved heart was out.
That's correct, Your Honor. I don't believe it appears
in the model instructions. And so I did note that it was present in the defendant's version that they requested. So I just want to hear, I want to make sure everybody has said whatever they want to tell me relative to that specific issue.
I think it's inviting a degree of confusion by adding another somewhat obscure legal term that does not appear in the model instruction.
Okay.
Judge, I think it's been used in other cases with similar charges, and so it's appropriate to use here.
Okay.
And it was upheld in other cases.
Okay, so once again, Attorney Kettles, going back to the NOMAR instruction, you indicated that your position is that is a correct statement of the law. I understand that it's been used previously, but you also indicated as part of your argument that it had been used relative to justified shootings?
Judge, I think that the NOMAR instruction, I believe, was crafted by attorneys Wines and Mayo, and I think that they did extensive review. The footnotes are in my original instructions that were submitted of kind of how the Attorney General's office has handled claims of self-defense or defense of others in the past. And so those footnotes, Judge, are in the original instructions that were proposed instructions that were submitted. Let me find when those were submitted. Back on September 3rd.
Okay.
And so I essentially, it's on page 3, Judge. I think it's essentially an argument of what's good for the goose is good for the gander, that if that's the correct statement of law and it's the standard that the Attorney General's office applies when dealing with officer-involved shootings, that should be the standard of law that the court applies.
Math is, that is funny.
Your Honor, the NOMAR case involved testimony from an expert in the use of force. So the use of force was an issue in that case in a way that it is not here. I think those jury instructions were tailored to that specific case. There is no such factual predicate for them in this case, where the defendant is, described the situation that we're in. It did not involve the same or similar facts, similar arguments about those facts, no expert testimony on the use of force here. So I think that while those instructions were found to be appropriate by the court with regard to that case, that doesn't mean that they're appropriate for this case.
Okay. All right, thank you. I will make some rulings on the record, and then we will take a break, and then I'm going to, during the break, I'm going to be starting to solicit from counsel their specific instructions on a few things. So I will be adding, from a structural standpoint, I will be adding the act in defense of others element to the individual components as it relates to the second-degree murder and knowing and second-degree reckless. In other words, I'll be adding the part that says that the defendant did not act in defense of other. I hereby grant that request of the defendant. With respect to the actual defense of others component, I'm going to deny the defendant's request to use what is being referred to as the NOMAR instruction. With respect to specific uses of individual defenses within 627.4 Roman numeral 2, with respect to A, I think that it's been established that A is not applicable under the circumstances. With respect to B and D, the court is mindful of the directive from the Supreme Court relative to the court's weighing of credibility as it relates to the previously referenced Kavanaugh case, and also the Brooks and Woodburn case. The court is mindful of the court's job not to comment on the merits of the case and to not impermissibly act as fact finder as it relates to Brooks and as it relates to Woodburn and the other cases mentioned. With respect to B and D, however, I'm focusing on the phrase likely to use, the issue relative to likely to use.
Deadly force.
There's a difference between, under the statute, a difference between A, which uses the phrase is about to, and C, is committing or about to commit. Whereas B and D, specifically the legislature chose to use the phrase is likely to use. Not whether the person is committing or is about to, but rather with B and D, the focus is the adverb likely to use. So based upon the evidence that has been presented, I'm denying the defendant's request with respect to B and D. And again, I am not substituting
they only get C.
Myself in the position of fact finder. I'm not commenting on credibility, but I'm focusing on the phrase is likely to use, both with respect to B and D, as opposed to is about to use or is committing or is about to use, which is a different sentence structure used by the legislature in A and in C. I am going to grant the defendant's request with respect to C. Obviously, we're not talking about forcible sex offense here. We're talking about kidnapping. So I'm granting the defendant's request as it relates to 627.4, Roman numeral 2, lowercase c. I'm aware of nucus as it relates to whether there's a legal predicate or not. I believe that the defendant has established that. So what I'm ruling is that B and D are not permissible. I am granting C. And I do think that there needs to be some definition of what kidnapping,
yes, please.
What we're talking about as it relates to kidnapping. So I am going to solicit from both parties their phraseology as it relates to kidnapping. Under the law, a kidnapping is blank. In other words, I'm going to grant 627.4 to C. Under
Isn't this
the law,
defined in New Hampshire already?
A kidnapping consists of, or a kidnapping is defined as, and then I need to have something as it relates to what a kidnapping is. And if the state chooses to propose what a kidnapping isn't, I will view that in the context of what the state, overall of what the state is proposing and what the defendant is proposing as it relates to how 627.4.2C will be applied under these circumstances. And I'm also going to adopt for purposes of ruling right now, I will adopt the Etienne phraseology as it relates to the degree of force, deadly force versus non-deadly force. So those are the rulings as it relates to what we've got to this far. Finally, I will not be using the phrase depraved heart. I will be using the second degree murder, the remainder of the second degree murder reckless component, with including the manifesting an extreme indifference to the value of human life. The rest of that, but not including the depraved heart sentence. So with respect to this point in the instructions, any questions from the state as it relates to instructions at this point? Attorney Spicer. No. Okay, Attorney Kettles.
No questions, Your Honor.
Okay, 15-minute break. And anything that I can receive relative to kidnapping, we'll proceed with the other counts. But anything I can get relative to kidnapping will help not just me, but help you. We'll get this done. We'll get this done by the end of the day. Thank you. We'll have a 15-minute recess.
All right.
So while they go to recess, let me. In New Hampshire, kidnapping is defined as knowingly confining another person with the purpose of holding them for ransom, avoiding apprehension, terrorizing them, or committing another offense. A person is also guilty of kidnapping if they knowingly confine another person with the intent to secretly confine them against their will or to send them out of the state. It is considered a Class A felony in most cases. Can a custodial parent kidnap their child minus a court order in existence? Wrong answer is only. Yeah. Depraved Heart is a good name for a rock band. Heart was already taken, P. Cooper. Here's what I'm worried about. The letter of the law, okay? The letter of the law, if you look at burglary, because it was not her house and because he wanted her to leave, her staying in it is committing burglary. It's entering or staying in a residence without permission. So now you get the burglary charge exists. And now you've got the threat to commit a kidnapping, like I'm going to take the kids, while in the commission of a felony, burglary. I think burglary is a felony. It might just be a misdemeanor. I'm worried that with each definition, with each definition of the law, they're barely squeezing the events into that category, and they're going to somehow weasel their way through by tiptoeing on each little brick and saying it applies here and it applies here barely and it applies here barely, and that can get us to not guilty. I think the jury's smarter than that, especially if there's some sort of statement that says that there has to be reasonable force, or if you know that there was a high likelihood that the event was going to occur. I think the jury will be all over that. But yeah, I hate the fact that they're here. Now, the fact that they are not married makes this a lot easier for the defense, in my opinion, because they were never married. If they had been married and just weren't living together, that status is, in the eyes of the law, they're still husband and wife, right? And then you've got, custody, you've got property issues that still have to be decided by the court. And were they to divorce, they could say, okay, that apartment belongs to him and this one, the house belongs to her. They can do that. But that's not the case here. They're just parents together. Is cameraman having a seizure? I think somebody's kicking the tripod is what's happening. People walking in and out. They'll get it fixed. All right. Now here's the question. It's 2:23. We may have some other things to watch today as well. In the world of true crime. Let's see. That's not it. Let's try this one. Well, we have a little break. Let me just check and see where we're at. Judge McNally is up today. We have another case that started today. Judge Wolf has been doing a little bit of lawyering, looks like with adoption. Let's see if we have any others. Tammy Rogers is up. Judge Mercer's been active today. Everybody's at lunch. Still on break. Judge Oakley has even been up today. There's no way that's right. Seriously, Judge Oakley's already been up? Where's he at? Yep, he was. Okay. All right. Is Cameron having a seizure? He was. Or we're not. I guess he still is, come to think of it. He's still happening. In Arizona, if the kids are in state custody, the parents don't hand them over after a visit. Parents are charged with kidnapping. If a parent doesn't return the kid to another parent, it's custodial interference. Right, but in both of those situations, you've got the court defining custody and assigning custody first, right? We don't have that in this case. We just have two parents who decided not to live together, who share children, and they've sort of decided on their own. The court hasn't said what was right and what is wrong. And I think that makes it a little bit harder here. Why am I seeing the pinned comments blurry? I don't know. Lizzie, that's awesome. We might be jumping to that one tomorrow after this. There could be an earthquake. This is a very long earthquake, if that's still happening. Andy Lumu. I think the prosecution is missing pointing out the fact that the child was not screaming until he tried to pull on her as well. And that way you've got two people pulling on the child. And the child in the middle is getting hurt. Just her sitting on the lap, she wasn't crying. She wasn't being hurt then. He's 50% equal for the harm being done to the child, if not more, because he sort of instigated it. But okay, the earthquake has calmed mostly. Guess I'm a little confused. So if she's trespassing, he has the right to pull a gun on her. Let's see, New Hampshire. In New Hampshire, the castle doctrine allows residents to use deadly force to defend their home against an intruder under specific circumstances, such as burglary or reasonable belief of imminent death or serious bodily harm. I don't think he can get to past the point, that word in there that says reasonable. I don't think you can get that. But burglary is a possibility. It is a stand your ground state, has no duty to retreat. A person can stand their ground to use deadly force to defend against threats in their home or any place they have a legal right to be. The law extends to situations involving kidnapping or forcible sex offenses as covered under RSA 627. Deadly force is permissible when you reasonably believe deadly force is necessary. Now, reasonable, once again, the jury's going to key in on that word, to defend yourself or a third person from unlawful deadly force. You reasonably believe a person is about to use unlawful force during a burglary of your dwelling. That's B. You reasonably believe a person is about to commit kidnapping or a forcible sex offense. That's the one that the judge is allowing in. And then D, you reasonably believe a person is about to use unlawful force while committing a felony against you within your home or its curtilage. So, A, you reasonably believe deadly force is necessary to defend yourself or a third person from unlawful deadly force. The judge is allowing that in, even though the defense didn't ask for it. They only wanted B, C, and D. The state said they should use A, and the judge said, I'm allowing A. I don't know why the state did that. B is out, unlawful force during a burglary, but C is in, you reasonably believe a person is about to commit kidnapping or forcible sex offense. Once again, the key word, reasonably. Reasonably. I think in both situations, the jury's going to look at that, and they're not going to get it any further than that word, reasonably, and will stop. Her not leaving is just his side of things. I'm not sure I believe him or that he told her to leave. Late but present, I hear you. This is terrible, and so many people have said this. Where's her voice in this, right? Where's Kat's voice in this whole thing? Why are we only getting his side of the story? Well, because she's dead. There is only one person left to tell the story. And it's sort of like the victor writes the history books. He's the one that gives us the story for things that we did not witness or have no way to find out what happened. So her voice is silent in this. And that's where the jury looks at this and says, is this reasonable? Does this make sense? There's her not speaking to you for 5 hours, and then suddenly in the 30 seconds before you kill her, she announces all her felonious intent on the children as far as kidnapping goes, and then she goes not speaking to you again, or when you shoot her. Is that reasonable? And I think they'll say no. She wasn't burglarizing anything. Well, this once again, this comes down to a definition, Groovy Cheryl, and I agree. Usually you think of a burglar as somebody who breaks in and steals something, but the term burglary can include staying in a location that you don't have the right to be in. When it wasn't her house, it wasn't her apartment, she wasn't on the lease, and she had been asked to leave by the person who did have the right to do it. So basically, it's a step above trespassing. But I can't see this happening. I think the jury looks at this and said, there's no way it should have got to this point. Even if she was supposed to be leaving and she wouldn't leave. The police were an option. There were so many other options that this is just not reasonable that it got this way. Let's see. Unlawfully entering with intent to commit a crime, right? Or staying in a place after you're not allowed to stay in. The more he talked on the stand, the less I believed him. The more I think he has completely concocted this story by doing two things. By being aware of the evidence and understanding the law and making it work. Why did he move to New Hampshire? What was in New Hampshire for him? He wanted to be in Las Vegas. Did he move to New Hampshire for this very intent? Was this like a plant? It looks to me like it was. I mean, New Hampshire's live free or die. There are lots of self-defense rights in New Hampshire. It's probably one of the easier states to argue self-defense. I wish they took a peek at his computer. I want to know what's on that. It's closer than Florida. Florida is also possible. All right, still at break here, so. Just happened to be carrying his gun around in the month leading up to it. He said that, and it has not left my mind since. Oh, he was always carrying his gun. There's so much he said about guns that is common sense, trained every single hunter safety class ever. And there's so much he said that is just ridiculous. Like, when you shoot enough, you know where your gun's pointed, even when you're not looking down the sights. Like, you develop a sixth sense, like an extra eye that can see down wherever the gun's. No, you don't. It doesn't matter how much you shoot. The reason you aim down the sights when you're aiming is because that's the only way you can see when it's shooting. Now, I can see a couple people that get muscle memory for some of those, quick draw and get the angle right. But they're firing at balloons, first of all, if you're looking at the cowboy quick draw stuff. They're firing at balloons. They draw their gun, and they're firing blanks that shoot basically like a shot of. It's not like a shotgun. It's not that big, but it's basically a shot of shrapnel, paper shrapnel, at an area that's pretty big. So you have a wide target, or you have a wide scope of impact for the balloon. And all the stuff you see on the movies, the quick draw and just shooting stuff off fence posts, it's BS. It doesn't happen. Even Annie Oakley with her mirror behind her head thing had to look down the sights and use the mirror to do it. Otherwise, she would have just shot over her shoulder and just known what it was looking at. Respectfully, yes, you do. You fire your rifle enough, you know where you're firing. Okay, but you don't fire your rifle sideways and know where it's firing. Because he shows the gun this way. He shows it horizontal, parallel to his body, basically, across his body. I don't buy that. Not in the slightest. Yeah, I think he could say, yeah, that's pointed at her head, but hope some gun owners are on the jury. I hope so as well. Nope, not on verdict watch. The jury has gone home for the day, and we have not had closing arguments yet. Muscle memory kicks in if you shoot the same, the same thing over and over. Repetition drilled in. Practice. I think in this instance, with the child was so close to her, he definitely aimed. What if he would hit the child? I think he was across the room when he shot her. I know he's told this story, and I said I think, originally I thought the daughter was in the mom's arms when he shot, and I still believe that was true because he told us now today. But now I think she was across the room because remembering what the ME said, that there was no stippling around the wound, the burn from the powder, and I realize the hair can block that. But combine that with the fact that he says he let it slip when State was cross-examining him, saying, you didn't go check on your wife to see if she was alive. And he said, I knew she was dead. But you didn't go up and check. He said, I never approached the body. Why would he need to approach the body if he was already right there, point blank? Okay, I don't think he ever was. Ever that close. From when the gunshot went off to till today. I don't think it was that close. I think he was across the room, aimed and shot, but was worried he hit his daughter, who was cuddled with her mom. And that's why he was checking her so closely to see if, maybe there was an injury on her head, going through her hair, making sure there was no injury. Because they were right next to each other when this happened. And he's just trusting his grade A aiming, 5 gold stars in the Army, great marksmanship, to make sure that he didn't hit the daughter. I keep saying wife, girlfriend, but yeah, I think he shot his girlfriend. She immediately went limp, and the daughter went screaming, and he chased her to make sure she was okay. That's what I think happened. All right, judge is back. Whoa.
Thank you. Please be seated.
With his gavel.
Sarah, is this me?
Oh, that child was in danger, I think, for sure.
No, do I? On the desk. Nothing there, nothing.
I don't know what it is.
Okay, thank you. Okay, I've been advised that I am receiving something relative to kidnapping.
Yes, the state filed, I think, what the court asked for, proposed definition of kidnapping and what kidnapping is not.
Okay. Okay, thank you.
90 seconds.
Thank you. Moving on to reckless conduct with a deadly weapon. Attorney Speicher, or Duren, whoever's doing this.
Your Honor, the state was satisfied with the draft instructions the court circulated. I think they accurately instruct on the law related to that offense. I believe the court has already indicated that you're going to add the additional element of the defendant did not act in self-defense, and that's already been ruled out. But otherwise, the state has no issue with the defense or with the instruction as written.
Okay. Okay.
And Judge, I think all we did was add the 4th element and then take out some of the additional language regarding deadly weapon because I think, and serious bodily injury because here the manner in which it was, you know what, Judge, actually we're fine with the instruction that the court gave with the addition of the final element.
Adding the additional element?
Yes, Judge.
Okay. So I will amend reckless conduct with a deadly weapon, charge ID ending in 222C relative to adding the state's burden to prove that element beyond a reasonable doubt of defense of another.
Another little win for the defense.
Okay, moving on to endangering the welfare of a child. The Attorney Speicher.
Again, Your Honor, the state has no issue with the instruction that is circulated by the court. I'll note specifically that the state believes the court correctly identified the the distinction between the dual intents there, and purposely violating the duty and knowing with respect to endangerment. So we do believe that is a correct expression.
And position relative to, three options. Do I force, three options. Do I force counsel to argue that there's a duty? Number one, do I request that counsel stipulate that there's a duty? Or three, do I simply enter a finding that there's a duty? For purposes of this draft, for purposes of this draft, without making an order, I posited that it would be within my province to indicate simply, without going overboard, simply to say under the law the court has determined the defendant owed a duty of care, as stated in the instructions. So, from your perspective,
I don't know if that's in dispute. I think it's appropriate to certainly take it out of the jury's hands as something they need to decide and make it clear that that element is not an issue. We're happy to stipulate. I don't know where defense counsel is on that.
So, Judge, I think it would be error for the court to issue a finding on an element. That is the province of the jury. And the defense is not going to stipulate to an element. It has a right to hold the state to its burden on this element. So we would ask that that language that the court has, it appears in writing line, it may be a different color in yours, but at the bottom of page 15, under the law, the court has determined to the end of the page that be removed.
okay, and
The jury won't be told.
okay,
that
if I, based upon the defendant's arguments, which I acknowledge,
defendant had a duty of care for his child.
Based upon that, Attorney Cattles, do you want me to do you want the court to define duty of care under the circumstances? And once again, for purposes of the record, in case it's not clear, I believe both counsel already agreed that there is no model jury instruction. There is no model jury instruction that we are aware of relative to this. Am I correct? Attorney Duren's shaking her head yes. So,
Correct.
okay.
Stay safe, Trumel.
Proposed instruction that we would ask
It's a
the court to
doozy.
do.
And the one, just so I'm clear, the one requested by the defendant does not include a definition or reference relative to the duty component?
Correct, Judge.
Okay. So, all right.
The judge is loud, the lawyers are quiet. I'm trying to balance everything off. Any argument on that?
No,
Okay, so with respect to endangering the welfare of a child, Attorney Kettles, if I strike the one that was on my page 15, if the pagination has not been changed, the one that was circulated to counsel, if I strike the sentence that begins under the law the court has determined, which I'm doing that, is there anything else in my wording that, and if I add not in defense of another, if I add that as an element,
I don't either. These lesser ones seem like they're much easier to reach a guilty on.
if I strike the comment about the court finding a duty, number one, and number two, if I add the not in defense of another element, both of which I'm going to do. The next question, I guess the next question that really I'm getting at next is, in the statute for which there is no model jury instruction, it includes two different states of mens rea. And what I attempted to do and how I wrote it was reference the purposely with respect to violating the duty and the welfare with respect to the effect upon the child. So I understand that the defense has requested their instruction, but if I add defense of another and if I take out the finding of a duty, does the defendant have any position as it relates to the relation of the mens reas, the relation of the two separate mens rea components to the individual action components of violating a duty and the endangering of the child?
Judge, our position would just continue to be that the proposed instructions that we filed on multiple occasions are the best instructions in which we've given in this case, based on in re and K.
Okay, so my observation, I understand your position. My observation is that the one requested by the defendant does not match up the mens rea with the individual actions, which if I grant the defendant's request in that regard, my concern is that I'm not adequately providing the jury with the necessary instruction under the circumstances. I'm still considering whether to grant the defendant's request, but I'm trying to find out if you don't want there to be a reference with respect to the mens rea component and the actus reus component.
Judge, I believe our proposed instruction discusses both the mens reas.
Your Honor, I think the court's instruction accurately captures this issue in the statutory language, and I'll cite State versus Bortner, 150, New Hampshire 504.
Okay.
That I think speaks to the interplay of those two, but I think it is appropriate to instruct as the court is doing.
Okay.
Can we get back to kidnapping?
Thank you. All right.
Let's
Moving
define
on,
kidnapping.
relative to, that concludes essentially the defendant's draft. Moving on to my draft. Again, I'm moving up the defense of another components. I'm moving that up so that it is coming directly after the elements for second-degree murder, knowing, go right into the the defense of another component at that point. So now back on my draft, I'm at page 20. My inclusion, the paragraph starting with multiple charges. Position on that? Multiple charges, alternative charges, position from the state?
No position, I believe that's acceptable.
Okay, Attorney Kettles?
Judge, with the multiple charges, I guess my concern is that if the jury finds that Mr. Duren was justified in causing the death of Caitlin Massacre, then that should lead to a not guilty verdict on the other charges as well, as any proportionality or any other kind of argument.
Not necessarily.
Would surely mean that he was justified in his actions that would otherwise constitute lesser offenses.
The state didn't disagree with that. Certainly the jury, if the elements are different, there's no overlap, these are not lesser included. There's no automatic function of law where the defendant would necessarily have to be innocent of other charges if acquitted on either of the murder charges. I think they are separate and distinct. There are scenarios where the jury perhaps could find the defendant not guilty of murder, but certainly still guilty of reckless conduct or endangering of a child.
And I think, okay, thank you. Attorney Kettles, any response?
I think our point is that if the jury finds that the state has not proven beyond a reasonable doubt that Mr. Duren was not justified, then that would result in acquittal on all four charges.
I think I'm explicitly positing that possibility by virtue of including a element in each of the individual charge definitions relative to the fact that the state has the burden with respect to each of those individual elements. So I think that takes care of that. The justification defense is essentially inserted into each of the element definitions in each of their constituent sections. So I'm going to leave that in as is. Okay. Alternative charges, Attorney Kettles.
Same argument regarding the element, or the only element I think meaningfully in dispute as to the two alternative charges is the acting in defense of another.
Okay. And the rest of it, I hesitate to use the phrase boilerplate, but with respect to the remainder of the boilerplate, so to speak, obviously it is extremely important. By saying that, I do not mean in any way to not indicate how important it is under the circumstances. However, when I use that phrase boilerplate, I'm simply saying it's the same usually from one case to the next. So I don't know if there's any specific challenges to any or questions with respect to that.
No, Your Honor.
No, Your Honor, just I guess request at some point that we could see the verdict form.
Certainly. No, I should have sent that. That's I'll get that to you instantly, soon. Okay. Anything else right now with respect to the instructions, Attorney Spicer?
No.
Okay. And Attorney Kettles?
Is now the time to discuss the definition of kidnapping?
Yes.
Then yes.
If we're ready to, then yes. Yep.
So, Judge, the state just a minute ago propounded a proposed definition, and I want to be clear that we continue to maintain our objection to defining kidnapping for all the reasons that we discussed before in terms of McDonald and Woodbury and the other cases cited in our motion. But I think the specific definition proposed by the state, or any definition that's kind of limiting us to the statutory elements, is an issue because the statute says that Mr. Duren would be justified if he reasonably believed that Ms. Knapsaker was committing or about to commit kidnapping. And so I think that it's instructive to look at the case law on attempted kidnapping. In State versus Casanova, 164, New Hampshire 563, the court explains that a person commits the crime of attempted kidnapping when, with a purpose that kidnapping be committed, he does or omits to do anything which, under the circumstances as he believes them to be, is an act or omission constituting a substantial step toward the commission of the crime of kidnapping. And Casanova also explains that the state was not required to prove the elements of kidnapping under RSA 633(1) to sustain the charge of attempted kidnapping. And so I think here where we have the possibility that Mr. Duren is justified if he reasonably believes that someone is about to commit a kidnapping, he doesn't need to reasonably believe that each element of the kidnapping statute was met. State versus Bean, 153, New Hampshire 380. The Supreme Court says, we noted that the attempt statute requires the state to identify the intended offense. This is an attempted kidnapping case as well, but does not require the state to plead and prove the elements of the intended offense. Since an attempted crime is by definition a crime not completed, the state could not plead, factually identify, and prove the elements of the intended offense as if it had been carried out. We therefore held that the state was not required to allege in the indictment a statutory subsection of the attempted offense. To convict the defendant of attempted kidnapping, the jury was required to find that with the purpose of the crime of kidnapping be committed, the defendant did or admitted to do anything which, under the circumstances as he believed them to be, is an act or omission committing a substantial step toward the commission of the crime of kidnapping. So the state's proposed instructions, first of all, I think their reference to essentially 633(1), Roman 1A is confusing and inappropriate, but second, it doesn't adequately capture that Mr. Duren would be justified if he reasonably believed that Ms. Knapsaker was about to commit the crime of kidnapping based on Bean and Casanova.
So with respect to the defendant's position that the existing phraseology in the jury instructions is sufficient as is and don't define kidnapping further at all, am I correct?
Yes, Judge.
Okay.
Yeah, that's not going to fly, Judge.
That it should track the language of the statute because the legislature has not referenced 633(1). It would be improper for the court to limit kidnapping to the offenses in 633(1).
And I'm reading what the state has filed.
Honored, that goes to the reasonableness of the jury thinking that she's about to commit a crime. No shoes, no car, doesn't know anyone in the area. She has nowhere to go and no way to get there. I'll tell you one thing, if he gets acquitted, I think New Hampshire will change their laws a little bit. There's that train again.
Judge, when the court's ready, I'll have more argument.
Certainly, just a second. So, Attorney Kettles, I guess here's my next question. If I don't define kidnapping, if I don't define kidnapping in the instructions, and then 10 minutes into deliberations, we get a note from the note that says that a certain juror has been picked as a foreperson. And then 30 minutes after that, we get a note from the jury that says, what is a kidnapping?
Then the court should instruct, use your common sense everyday definition of what a kidnapping is.
No.
That's what I think that's what the legislature says. That's what the statute says. Judge, I'll note, in addition, on the state's proposed instructions, that they've narrowed it down essentially improperly just to kidnapping and not to about to commit a kidnapping. And then by using that paragraph, it is also important to note certain behavior that does not fall within the definition of kidnapping, followed by a lengthy sentence. Judge, that is certainly including language in 627.4 that the legislature did not see fit to include. And there's many sites, I put them in my pleadings, about statutory interpretation. The court cannot add this full page of definitions that the legislature did not see fit to include in 627.4. The state is trying to use a different statute that's not referred to in 627.4. This is not a term of art. The legislature knows how to create a term of art. It knows how to refer to other statutes. They did not do so here. And so the court is limited. It cannot add language the legislature did not see fit to include, and that's what this entire page that the state has submitted is.
Okay, and you also, was that also the further argument?
That was the further argument, Judge.
Okay, all right.
Your Honor, I think the court has already expressed that it is appropriate to define kidnapping to address the very situation that Your Honor just brought up, that the jury may very well wonder what kidnapping means. The most appropriate definition is the one contained in RSA 633.1, and that's what the state has included here. The state has not changed that definition or added to it or retracted from it. We believe that is the appropriate definition, and again, we believe it is appropriate to define kidnapping for what it is and also what it is not. We did include in brackets that a person commits the crime of kidnapping if they can find another under their control, do so knowingly, and the person acts for purpose to, and then we include each of the 4 scenarios in subsections A through D. We would suggest that only those scenarios which contain some supporting evidence would be appropriate to give. We included them all here just for completeness. But I don't think that there's any supporting evidence that the defendant reasonably and actually believed that Ms. Nafsir was committing a kidnapping by confining Elwyn to avoid apprehension by a law enforcement official, because we don't believe it's appropriate to include that. That Ms. Nafsir was confining Elwyn to terrorize anyone, or that Ms. Nafsir was confining, or that Mr. Duren believed Ms. Nafsir was confining Elwyn to commit an offense against Elwyn. So really the only one of those 4 scenarios that we believe would be appropriately included would be the first one, hold the person confined for ransom or as a hostage. That's the argument that the defense has been making. So we believe that one would have some support, and that is the only one of those 4 scenarios that should be included. And again, with regard to statutory interpretation, the state submitted a pleading with multiple citations regarding statutory interpretation as well. It's our position that it is appropriate to define kidnapping in this scenario.
And so once again, Attorney Spicer, with respect to McDonald 163-115, the statutory interpretation of defense of others includes the phrase forcible sex offense, which there's discussion in McDonald that it's not coextensive with aggravated felonious sexual assault in McDonald. Would you agree with me relative to that? So even though the McDonald says use the regular phrase forcible sex offense without getting into defining it, the state's position is that that's okay with forcible sex offense, but it's not okay with kidnapping?
I agree, because there's no crime of forcible sex offenses. This is going back to Davidson, where we're talking about an unlawful taking, and it's okay to have unlawful taking, and that is not a reference to a statutory definition, but it includes more than one potential crime. Here, there's a reference to kidnapping, which is statutorily defined. It is not a broader category of crimes. The parallel here would be if the language was not kidnapping, but interference with freedom. And that's not what the language says.
And am I also correct that the state's position is that once you answer the question that you just asked relative to the forcible sex offense versus aggravated felonious sexual assault, once you get past the McDonald question, and once you say that we need to define kidnapping, the state's position is also that the legislature hath spoken relative to defining kidnapping to also include what kidnapping is not.
Yes, and I think we're talking specifically in the context of kidnapping for purposes of justification of deadly force, where I think the context of that is very important, and then the interplay between 633.1, 633.1-A, and interference with custody, 633.4, indicates that whatever kidnapping is, we know what kidnapping is not. And Ms. Nafziger legally could not kidnap her own child for behavior consistent with interference with custody.
Yep.
And there is a great risk that, based on the testimony and the evidence, that the jury may act on a mistaken belief of the law that that is what kidnapping is. And that we want the jury to understand what kidnapping is and what it is not.
Attorney Spicer, I haven't made my mind up yet as it relates to this issue, okay? So my next question for you is, if all that's true, am I invading the province of the jury as it relates to giving this specific instruction as it relates to the elements of the general offense? Am I impermissibly, does that instruction that you're asking me to give, does that impermissibly invade the province of the jury, and or does it essentially does it mandate a specific outcome which is impermissible under the law?
No, I think the court would be simply, defining the boundaries here, and then the jury is free to make its own decision about whether things fall on one side or the other. The court is not instructing as to any of the elements or whether or not the evidence has satisfied them in favor of the state or otherwise. The court would simply be giving a definition of what kidnapping is.
Okay, thank you.
The way the legislature has written the statute, the only guidance that the court can give is the word kidnapping or about to commit a kidnapping. That's what the legislature has said. The legislature has explicitly omitted an interplay between 627.4 and 633.1 or 633.1A. The legislature knows how to connect those statutes, and it chose not to. And the court cannot ignore that deliberate choice of the legislature. The jury should be instructed on what the statute says, and then from there it gets to use its own interpretation of what kidnapping is. I'll note without that is our position. I think that's the correct reading of the statute, but some additional issues with the state's proposed definition is that the final paragraph creates a risk that the jury will believe that Ms. Nafziger could not kidnap her own child, full stop. And that's incorrect as a matter of law. And then also I do think that evidence has been presented that Ms. Nafziger acted with the purpose to terrorize Mr. Duren through her actions. So again, the court cannot create an interplay that the legislature does not say exists. The court cannot instruct on the definition that the legislature has not given in 627.4.
And for the record, again, legally as opposed to factually, that's why I issued the order I did a couple Fridays ago asking for instructions. I know counsel already knows that, but I knew we were going to get to this point. I didn't know. I take that back. I didn't know we were going to get to this point. My assumption was we were going to get to this point where we are right now, and I wanted to make sure that we had adequately briefed the issue. And I know counsel has competently and with great care, counsel has competently briefed the issue relative to both sides. So
Judge Rule.
That is why I wanted to focus everyone on what I did a couple weeks ago, which is why we're here right now. Okay, anything further, Attorney Spicer?
No.
Attorney Kettles, anything further?
No, Your Honor.
Okay, all right. So once again,
rule on kidnapping.
I'm going to make my mind up. I'm going to take a brief recess. I'm also going back to the...
He loves his breaks.
It's the child endangerment, and I'm going to check one thing, and I'll make a decision as it relates to this specific issue. And
he loves his breaks. Sorry, I'm hitting the wrong buttons.
Again, I haven't decided what to do, but Attorney Kettles, if I grant the state's request, it's hostage and terrorize?
Ransom.
Yes, Judge.
It's ransom and
all right.
Hostage.
All right.
You're doing hostage and terrorize?
We're getting there, counsel.
Okay, all rise.
Oh, and I'll get the verdict form disseminated right now, also during this break. Be back when I can. Thank you.
Coolest County Superior Court is at recess.
This is a tough thing. The judge seems to be dithering where he shouldn't dither. Maybe I used that word wrong. Sorry, Judge, if I did. But it seems more common sense than what we're doing. We're like down in the weeds, and we're like, this is a 5,000-foot level. It's a pretty easy decision, and the further we get in the weeds, the more the actual decision's obscured. And I'm like, if you're not careful, Judge, we're going to decide this right here. By abundance of caution. There's so much abundance of caution to make sure that there's, the rights are preserved, which, there should be the rights preserved, that we're bending over backwards to give the jury every possible option to make sure there's a not guilty. And even as I'm saying this, I'm strongly, I believe that the state has to prove. He's honking outside like a semi honking right outside my house. The state has to prove somebody guilty beyond a reasonable doubt. What I'm getting at is this seems beyond reasonable. Hello, Paula Mack. It seems beyond reasonable for this level of scrutiny of the whole situation. Do we define kidnapping? Do we not? Do we just leave it up to them to just and if they ask us, we just say, you decide what kidnapping is. We're not going to tell you. I think the jury, weeds are backwards. They're bad. Wasn't you, Ricky? Thank you. We've gone no steps forward and 3 steps back. The judge is going to define kidnapping here because apparently in New Hampshire they have not done that yet. The legislature has not defined kidnapping. I refuse to believe that. At least when it comes to jury instructions. Just put the statutory definition of kidnapping in. They're saying they don't have a statutory definition. But you've got knowingly confine another person with a specific purpose of holding them for ransom, using them as a hostage, terrorizing them or another person, avoiding arrest, or committing another offense against them. That's a person who's guilty of kidnapping if they, one of the following things. Sounds like he needs to phone a judge. Are they done for the day? No, they're not done. It's in break time right now. That's it. We're in break time. The judge is going to rule on kidnapping here in just a minute. Come on. I think I need a snack. I'm going to have water. By the way, I had salad for lunch, and then I was still hungry, and I did not eat a cookie. I was good. And so I had the one thing I've mocked a lot, but I actually do like, and that's avocado toast. It was really good. Have some nuts. Those are good. The only ones we have right now are candied pralines. Candied, I forget what they are. It's a candied one, so it's probably not the healthy version. She wasn't leaving. He was wanting her to leave. How was she then kidnapped?
Don't put a diplomatic plate on it.
CDJ, his story is that she was about to kidnap his daughter. You'll dream of cookies tonight? I probably will. He didn't want her to phone the police. That would have been a reasonable solution there. Yes, he didn't want the police involved. As a matter of fact, the prosecution on cross-examination of the defendant on the stand basically raised that. Said, you wanted to get out of you knew you had to get away because the police might be coming. Yep. And you brought several changes of clothes because you were going to be on the run. Yep. And you drove past several police barracks. Yep. Yeah. If he literally thought she was going to kidnap the sweet girls, he had ample time to contact the police. Yes, he did. Did not want to. John Gary, I just read that, the 5 out of 633.1. But apparently the legislature has not given a standard definition for the courts to use in this case or something. That's what the judge was saying. That's why he wanted the lawyers to provide one. Seems like the law is good enough. Took the time to unplug your PC tower and take your backup hard drive because that's essential for survival. That's his income. He's going to be doing that on the road, which means he's probably not going to be turning himself in. I'm guessing that that his initial reason to call his mom was not to say, I just called to let you know you need to call the police. I'm guessing that came probably, I don't know, 8 minutes into the conversation. She's like, I need to call the police. And he's like, why? Don't. They'll just lock me up. I don't think it was his idea. I don't believe him at all. If you don't believe him at all, you don't believe what he says she said, right? If he's not credible, then the evidence that she was going to kidnap the kids is also not credible, unless you believe Brenda. Brenda said there was this plan, right? But the Praline ones are dangerous. Oh, they're so good, though. So good. Grim-fated police and courts notoriously favor mothers when it comes to custody issues. I could see why he would be hesitant to go that route initially. I don't know. With her saying you've moved out of state with the girl, it doesn't make sense. The police are going to walk up and they're going to be like, hey, we're separated. We've got our kids are separate. You flew over here with one of the kids. I have the other one. There's paperwork. There's the plane tickets to show. I don't think the police would be arresting anybody if they showed up, but they would probably have her leave because it's his house. It's my belief he lured her to New Hampshire to try and already have her at a second location and get away with disappearing with his girls. Well, he said that's his goal. End goal. He has the girls. She's gone. Mission accomplished. I never thought of this as murder. Yeah. What about as soon as you shot her, I thought immediately, I'm screwed. Why would you be screwed? Immediately after you shot her in self-defense. It wouldn't happen. It's not a victory until Caitlin's gone. His words, yeah. He wasn't hesitant. He went to a lawyer. He just couldn't pay the retainer. Yeah, so this was a last-ditch effort. I can't afford the legal process. I can do it on my own. The lack of evidence about the relationship prior to this is evidence itself, in my opinion. No, there's been none of that. We heard in what, 1 or 2 sentences how they met, and she immediately became pregnant. And after that, there's no talk of their relationship whatsoever, unless it's negative direction towards Caitlin. Thought he was in neutralize the threat mode. How did he even know what he was doing? That cauliflower, neutralizing the threat. Part of that is assessing the threat level, and recognizing that, a frayed rope could break, right? That's different than if you try to swing on a frayed rope, it could break and somebody could be hurt. That's different than a knife is flying at me currently in the air and at a trajectory to impact me. The threat level is much higher with the knife than I could get hurt if this rope breaks. And he needs to assess the threat level. And the mom holding the daughter on her lap, who had been there for a while and not crying, was doing just fine, just being held by mom on the couch. The threat level there is non-existent. It's like nil, zero, zilch. There is no defense. I'm with you. He was the only threat. He has a gun safe, but he never uses it because he always has the gun with him. And he never keeps it in ready position 1 because he's always safe. But today it was in position 1. He just picked it up. Or no, he always keeps it ready to fire. But today he had to rack one in the slide. And it's just, the story does not add up. Grr. And he lied about the gun automatically defaulting to fire mode when you rack it. The safety does not switch on the Beretta 92F. It doesn't switch when you rack the slide back. It doesn't go to safe or to fire. It doesn't switch from one to the other. And he keeps it right on the desk where Elwyn can reach it. In the room where she was sleeping, not in his room. Yep. I think he created a scenario in his head that wasn't happening. Yes, he did. She was barefoot in New Hampshire in winter, but she was going to kidnap her own daughter. Yeah, I hope the jury can see through that one. Mandy Lumu, this is correct. Some states it's a crime. Should be in more. But he constantly had his eyes on it. Yeah. And he knew where it was going to fire at all times. Forget how long she had been there prior to the incident. She had shown up the day before, stayed the night, got up in the morning, and was there for 5 hours that day. And he's like, okay, now you need to leave. And she didn't want to leave. I don't know when the judge is going to come back, but we're here. By the definition of kidnapping in New Hampshire, she was actively kidnapping the daughter. So am I kidnapping my kids if I tell them, you've got to stay here and finish your chores before you go anywhere? Where did the parents' rights end and kidnapping start? I mean, have you ever picked up a screaming baby that doesn't want to be held, that just wants to throw a fit? Are you kidnapping the child? It's obviously against their will. Does it have to have the ransom? I don't know if they connected, his testimony connected her demand for more money for the other daughter, which is basically child support. I don't think you can count that as ransom. You can't 100% kidnap your own child. I guarantee there's dads in jail in New Hampshire right now for kidnapping their own kid. Problem is, this isn't black or white. I guess I've kidnapped mine a bunch. Well, we're admitting, how do we know the daughter did not want to sit on her mother's lap? No one only can find all the judges back. Here we go. We're going to hear what the definition of kidnapping
Once
is.
again, for those uninitiated in this process, the reason this takes so long is because we need to make sure that we have all the evidence in, number one. And number two, the reason we're doing this is to make sure that counsel can adjust their closing arguments based upon how they know that I'm going to be instructing the jury, which happens after the closing arguments are conveyed to the jury. So I think the final issues before the court that needs to make a decision on with respect to the endangering the welfare of a child count, I'm going to maintain the version which is included in the draft that was circulated, with the exception of removing the court making a finding relative to duty and inserting a element relative to the need for the state to disprove that element beyond a reasonable doubt. Excuse me. The fact that the defendant did not act in in defense of another, that the defendant acted in defense of another. That I'll add that element as a fifth element. I'm taking out the recitation to the court, making a finding relative to duty. Relative to the legal issue relative to definition of kidnapping, I thank the state with respect to its prompt ability to submit a document relative to the definition which is being advocated by the state. Let the record reflect I've gone back and reviewed State versus McDonald again, 163 in New Hampshire 115, relative to an analogous, not necessarily on point because it's a different nature of the defense, but to an analogous situation, and I'm going to grant the defendant's request relative to not providing a specific definition.
Wow.
As requested by Attorney Kettles. I reviewed the state's request again. Again, I reviewed State versus McDonald, and brief shepherdizing relative to running that case forward for any negative authority on the applicable point. I did not see any, so as a result, I am going to grant the defendant's request relative to leaving the term undefined or using a non-statutory defined meaning. Am I correct, by the way, you're advocating, Attorney Kettles?
Yes, Judge, being undefined.
Okay. I've also circulated the proposed special jury verdict form. Any comments with respect to the verdict form?
Your Honor, the only comment I have is a suggestion that perhaps with regard to the two murder charges, it might be helpful to include knowing or reckless, just so that there's no confusion on which charge they're.
Okay, anything else?
No.
In addition to that suggestion, Your Honor, we would prefer that not guilty be first and then guilty.
Okay, any objection relative to including knowing and reckless relative to parentheses? No. And switch not guilty and guilty?
Yes.
Any objection on that?
No.
Okay, court will grant that request and will interpose or will flip around that guilty and not guilty relative to that. Anything further, Attorney Kinney, on that?
No.
Okay, all right.
There it is, Amber.
Attorney Special, what have I forgotten?
I don't think anything.
Attorney Kettles, what have I forgotten? I know everybody. I know people have maintained their objections. Everybody's maintained their objections. Are you satisfied with your record, Attorney Special?
Yes.
Attorney Kettles, are you satisfied with your record?
Yes, Judge. The one thing I noticed, there's been a lot of discussion once we, I don't think that there will be, but once we review the final draft, if there is any concern, notwithstanding the objections we've already made, but I'll address it immediately once I've seen it right now.
Okay. So, just so I'm clear, nothing I've forgotten, and I mean, I'm going to get to the next 24. I'm going to get to the next 12 hours procedure in just a second, but nothing else I've forgotten, and you're satisfied with your record at this point?
Yes.
Same thing?
Yes, sir.
Okay, so what I will do in today's modern society is email addresses aren't that difficult to figure out. We already have everybody's email addresses. I will get this concluded. I'm not sure if it'll be concluded before 4:30, 5 o'clock. I'll get it concluded and get it emailed to folks. My only order, I'm going to be emailing it directly to all four counsel. The only thing I'm going to say is do not email me back. Do not email me back because I'm going to decline to respond. If there is an issue, if there's a typo issue, I encourage counsel to email each other and leave me out of it. If there is if any of my rulings are unclear, I hope they're not unclear so you can prepare your closing arguments. But if there is a drastic issue which needs to be addressed, we will address it before closing arguments tomorrow. We'll get that fixed. But hopefully I've provided enough instructions right now relative to my rulings so that you can prepare for closings. I will email directly because my excellent monitor will be, I'm not going to get it done in the next half hour, but I want to take the time that it needs, that it deserves under the circumstances, under this important case, and very good lawyering by both parties relative to the issues at hand. Clerk Restaurants, anything I'm forgetting from your perspective? Okay.
Do you want to ask them back at 8:45 tomorrow just so we can see if
Can we 8:45 just to be safe? 8:45. In other words, I'll be ready at 8:45 if we do have to address anything. If there is nothing to address, then we can proceed right to closings at 9 o'clock. Okay. Okay.
I don't know.
Okay, all right. All right, thank you for your work today.
You're welcome.
And that's why we didn't hold the jury. And we'll see everybody at 8:45 tomorrow. Thank you.
That means it's 8:30 for us, but early morning. Let me give you my thoughts really quickly, if I may. I think I'm not happy with the judge, but I can't fault him entirely because New Hampshire law is what the judge is reading, and New Hampshire case law is what the judge is basing his decisions on. So this is either. Do you need thoughts music? I've only got sad. I've only got this one. I can't blame the judge for everything here. He has looked at the arguments, he's looked at the case law, he's looked at the law itself, and he's making rulings based on that. And in this case, we just haven't had enough of these type of crimes in New Hampshire to lay that path, clearly before him, that we don't have decisions like this. We don't have other crimes that match close enough to this, that the legislature has taken the time to address directly and say, in this situation, this is what you do. It isn't there. And the judge, in seeing this, has looked at every fork in the road, every option that is presented to him as he's preparing these jury instructions, and he's asking both sides, give me your input. And the defense is giving a lot of input, saying we need to consider the fact that because the legislature has not specifically spelled out these rules, it was for a reason, and it should be broad enough for us to interpret just using our own mind power and the jury's own mind power of whether or not it was included in what the law exists right now. Every time they use that argument, the judge says, that sounds reasonable, and I'm going to allow that in. And you're right, I'm not going to step on the jury's toes. The jury can decide that. But in doing that, he has opened up a path that I never would have thought would be here, where the jury can look at this case out of the instructions they're given and the instructions they're not given and see a straight shot from closing arguments to not guilty. And I have to say, Judge, why not just take the extra step? Why go through the motions of bending over backwards? If you know the outcome, you had the opportunity twice during this trial, why not just go and grant the judgment of acquittal when it was asked? Because I think that's what he's pushing for in this case. I know judges are supposed to be unbiased, but I think he's put his hand on the scale and it's tilting just a little bit in one direction. Those are my thoughts. There you go. Didn't really work with that music, but judge is doing his job and applying the law. I agree, but and the law is poor. The law is poor. At least it's poorly defined in some of these areas. Like we've got the RSA. What's RSA? New Hampshire's Revised Statutes Annotated 633(1), but because the legislature hasn't clearly defined something, he can't define it to the jury. So now the jury goes back there. They just have to assume they know what kidnapping is, or hope they know what kidnapping is, because they're not going to be told by the court, and they're not going to be told by the lawyers in closing. If you think it's kidnapping, well, then it's kidnapping. That's what they're going to be told. Should have said it's a big deal. I don't know why you think that didn't work, because that hit the nail on the head for me, Embry. Thank you. It's still very unclear for me, and I don't want to blame the judge. I just think that so many decisions during this case have leaned in favor of the of defense in what seems like in an abundance of caution type thing. Normally, here's the rule. Here's what I decided to do before. In an abundance of caution, we're going to bend over backwards. We're going to allow this. We're going to not allow that. And this bending over backwards, at some point, we're looking at our own butts because we've gone a full loop. We've bent over that far backwards, and it's not accomplishing. I don't think it's accomplishing what the courts were meant to accomplish. If you look at this on the face value, okay, look at the facts of the case as we know them. We've got a mom wrapped in a blanket holding her daughter on a couch, and she was shot in the head, and we're saying it was kidnapping. That's what the judge is saying. Yeah, it's probably kidnapping. To the jury. What define kidnapping? I can't do that. Is it kidnapping, or it could have been a kidnapping? You pick me up. Gray is the new green. Oh my, Becky, look at her butt. It's just out there. That's funny. I can't blame the judge entirely. This is a decision, or his decisions are based on a whole bunch of other decisions that have happened in New Hampshire, and a bunch of laws that either exist or don't exist in New Hampshire, and judges in general just don't like being a trendsetter, right? They're not the first person to wander out into the savannah and carve the trail out of the jungle. That's not a judge's job, nor would we want one to be that way, right? We don't want a judge to just go out there and just blaze their own path through the legal system and say, this is the way it's going to be. And, if you don't like it, appeal and overturn me. We don't want that either. But there are some times where you can follow the clearly blazed path, the case law that exists, and then you can get to a point where you have to make a decision and say, in this case, in my situation, in the facts that are presented right here to the jury, this doesn't apply. Now we can see that clearly. We see the words in the law that they're not addressing our situation, and we know that. And it's not directing us to do something, and I've got the authority to make a decision, and I'm going to do it. And then, if you don't like it, overturn me, instead of just always just bending over backwards. All right. And that said, at the same time, the state has to prove every single element beyond a reasonable doubt before you can convict. All right. Now that I've had my little, this is what eating salad does to me, guys. It makes me a little grouchy, I think. It makes me grouchy. No more salads. Salad makes me grouchy too. Feed RA a salad every day. Red Pen's like, we want the grouch. Bring out the grouch. All right. It's 3:30. It's a bit early. Let me check and see if we have any of our favorite courts to go and watch. We don't want to start let's see. This one's not going right. No, that one's not started. We don't want to start another trial just yet. Let's go here. Can we do that?
Any permit?
Whoa.
The tab or tag or anything. So maybe they got tickets too. I have no idea, but I was pretty reasonably sure that where I was parked was fine, because when I looked around, I seen no signage. When I looked at other places, I seen in front of the building there was a barricade and there was a sign and there was signage and the meters were blocked. So it was just confusion. I was confused, so I wanted to just make sure I was.
Yeah. Parking meter.
I'm not too familiar with Royal Oak area.
From somebody if somebody would have been familiar with the area, they would have known that you could never get a parking space that good because you were right by the edge.
True. I mean, I thought it was too good to be true, but really someone had just moved out of that parking space. So I thought, they were done, and I just got lucky. So maybe they were to
split the difference with you. It'll be 25 instead of 50. So you can pay it online or by mail, or at the courthouse counter if you prefer.
Paid online at
If you do allpaid.com.
Okay, allpaid.com, keyword PLC.
And then the court's number is 3031, 3031.
3031.
And then if you put in the $25, it'll take it, and that'll work.
Okay, well, thank you for your time, and I appreciate you splitting that with me.
Okay.
All right, have a good day. Thank you.
Too good to be true. We got a good parking space. It wasn't actually a parking space.
We got Kaylee Zikic.
Kaylee? Kaylee, come tell us your story about parking in Royal Oaks.
Hello.
Hey, how you doing?
Good afternoon. How do you pronounce your last name?
Zajac.
Just like it looks.
Yeah, just like it looks. It means rabbit in Polish, actually.
Hello.
Oh, sweet.
So it's really pronounced Zions.
What? Zions?
So this is 25P 227787. You wrote a letter, and
she's a rabbit.
Basically, you live on Washington?
Yes, I have a residence there.
And you parked, the ticket was issued on Harrison.
Yes, so there was I have the permit for Washington within like 50 feet of the building that let me park in that area. It was kind of given to me by the apartment complex. And then without my knowledge, I displayed it in the window, and it must have been when the wind or my door closed or something like that, it flipped over to kind of cover up that address that I think would be needed to confirm.
I doubt very much that the wind flipped it, but it's certainly an easy mistake to make, to just put it the wrong way. And if you live there, you had to put up with all kinds of grief anyway. So I'm going to call this, it's clear that you're responsible. I'm going to waive the fine and the cost.
Okay, I appreciate it, Your Honor. Thank you.
The last guy had to pay $25 because his last name wasn't Rabbit. He's pro hair.
So you were good to go. Thank you.
Okay, thank you. Do I just log off?
You just log off.
Perfect. Thank you, guys.
Have a good one.
The luck of the Polish, as they say.
One other person. Is your name Madison Nordman?
Yes.
And this is 25P 228078. This is an Arts Beats and Eats permit parking case. You wrote a letter, and you said that you parked near the house.
Mm-hmm.
But the address we have on you is Commerce Township.
Yeah, I got the permit from my friends that live right there, and we just parked across the street and then put the permit in the driver's side window on the car.
Apparently you put it so that the address didn't show.
Yeah, which isn't really clear, the instructions on that. And so we got to.
What part did you find not clear?
That the side with the address had to be visible.
Doesn't it say that?
In big bold letters?
It does, but it didn't say, I didn't read through it all, and it didn't say it clearly. And we had a ticket, and the car on both sides of us also had the same ticket.
Okay, what I'm going to do is split the difference with you. So instead of 50, it'll be 25.
Should have said your name was Rabbit in German.
Okay. Oh, thank you.
Thank you.
And it's still the same citation number and everything that was on? Okay.
Yep.
Perfect. Thank you.
Thank you.
Am I good? Is that it?
You are good to go.
Okay, thanks. Bye.
Can I leave now?
And we are at 3:40. He started at 3:31, so we finished your docket except for the people that aren't here in 9 minutes. So let's see, we got to give them another 5 minutes.
So he's gone. He's gone. That was a quick little traffic court there to be a little palate cleanser. Let me see if we got anybody else. Judge Boyd, we haven't been there in a bit. Let's check in with her real quickly. Look at those flowers. I see 4 distinct vases. Happy Boss Day. That was from last week. Those flowers probably need to
Oh,
retire.
Norman, can you call Christopher Ramos back, please? Hi. You have someone else on the docket.
Who is it?
Excuse me.
Yes.
Yes, my understanding is that he didn't show up.
All righty. So we need to put that on the record.
Yes, Judge.
All right. Court is calling 2025 CR 011324, State versus Richard Wayne Esquivel. Could I have parties announced?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 2:41 p.m. The defendant has not made an appearance. Deputy Laura, did the defendant ever appear outside?
No, Judge.
All right, defense, have you had any contact with your client?
No, Judge, and customarily what I do is I reach out as soon as I get the appointment. I've reached out several times to him. He's never responded to me.
All right, state.
We would be requesting a bond forfeiture at this time, Judge.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Richard Esquivel on page 6.
Judge Boyd does not look happy today. The jury will get the instructions tomorrow. First thing in the morning.
The zombie apocalypse may be upon us.
I think she's almost done for the day. It's awfully quiet there. Faults, Bears beats, Battlestar Galactica. I love The Office. That is a great reference there. Cass, the sass. That's awesome. I booked myself in for a back massage tomorrow. Oh, that sounds... Finally doing something nice for myself in my back, so I'll be super relaxed by the time court starts. Probably asleep, Lizzie. Every time I've gone for a massage, I'm just like, oh, I melt. Did I tell you the... No, I'm not going to tell you that one. I'm sorry. Talk to Mrs. R.A. first before I tell that story. Closing first, then jury instructions. Okay, she said I could share it. I just asked her. All right. So it goes like this. Mrs. R.A. wanted to surprise us with, I think it was like an anniversary gift or something. And she's like, hey, oh, here she is. She's going to tell the story herself.
I want to hear what you have to say about it.
Let's go here so we can see you just a little bit. Where are you? You're through the skeleton.
Skin and bones.
Scully's going to be right here, and you're going to be right there, and then I can barely see you. Okay. I'm uncomfortable already. Where could you be that... Here, let me just swing this out, okay?
I can just
be right there. Just be right there.
Just be... I want to just stand on the desk.
This way. There we go. Now we can see you a little bit. All right. And I can look at her as well. Okay. Here's my story, and I'm sticking to it, right?
Okay.
It was an anniversary gift? What was it you wanted?
I think it was an anniversary.
Okay. And Mrs. Ari, she likes to surprise me with things. She's really good at that. And so she's like, here's something we've never done. couples massage.
Which sounded like so romantic. It might have been Valentine's Day, actually. I don't remember.
Yeah. And so yay. So what did you start at Craigslist? Where did you look?
I mean, it was so long ago. I think I looked in the yellow pages. I just looked for, no, I probably searched the internet and just was like, hey, couples massage.
Yeah.
Where is that
offered? Imagine Google, don't Google that. First of all, don't Google that.
Yeah.
But you did find some results. You found
I
some
did.
places.
I found a bunch.
You were going to book me a massage.
Both of us.
Yeah. And
So do you guys know what a couples massage is? It's not really that big of a deal. It's just that they'll.
It's like splitting the room charge, right?
It's like having a
I'm booking
roommate.
a massage, but there's going to be a roommate present. So there's two people getting a massage at the same time.
So we're not doing anything. I'm not giving him a massage. He's not giving me a massage. Somebody else, two other people are going to be giving us massages, and we just are in the same room at the same time. That's all it is.
So you'll be here like, oh, you missed a spot. Oh, ow, oh, that right there. Oh, that's the one.
Right? And that's how you bond.
It's bonding. It's close. Two tables, two masseuses or masseusal people. Massagers.
I don't know.
Anyway,
we're dragging this out.
So you make a call. You
Yeah.
go on Craigslist. You find a listing. Somebody's like, massage, call for, great massage something.
Right. Will you guys go out? This is not
go
for
out.
little kids
It's
to hear.
not. You guys don't want to be here.
Go out, please, and don't listen on the iPad. Go in.
Kids come walking in. We want to hear a story. Nope, not this one.
Not this story.
And their response was like, Mrs. Ari was puzzled.
It was bizarre. When I called them, I was like, "Hey, do you guys offer couples massages?" And they were like, "What's that?" I was like, "Oh
couples?
no, I've done enough research. I'm like, that's a real thing. I didn't just make that up." I was like, where you have the husband and the wife come in and they get a massage together, and she
they're like,
laughed at me.
Usually, it's just the husband.
Yeah, she was like, "No, we don't really do that here." I was like, "Well, okay, that's fine, whatever." And then I went and I was looking at the ad. And the ad was like, oh my gosh, red flags everywhere. It was like, men, come in, have the greatest
You'll
time
be
of your
happy
life.
you came.
You'll leave with a smile on your face. We have the most beautiful masseuses ever.
100% satisfaction guarantee.
I was like, oh my gosh, what?
I don't know what she was trying to sign me up for, but we did eventually.
It was bad.
We found actually a referral from there's a lot of people at my work. There's a massage place, like a legitimate therapy massage place.
Yeah, we did get it.
We
and
went.
it was awesome.
It was really good.
But not at that place. That place, they were like, lady, you don't know what you're getting into. I was like, you are not wrong. Wow.
So next time you go to buy a gift for the special someone,
do a little research. Yeah, I was glad I didn't buy that one for you. That would have been really bad.
Yeah. Anyway, that's hilarious. I thought I'd share that one. I don't know why we ended up there, but we finished court a little bit early today.
You're talking about murder cases, and then what are we talking about?
I don't know how we got here, but at least it wasn't actually booked there. Yeah. She tried.
Yes. I know. I did. I was like, well, I mean, other places offer it. And this lady, she's just like laughing at me. I was like, this is the worst customer service ever. What's going on? Oh, never mind. You're right. I do not want to come to you. Never mind.
Good fun. Where was this place asking for friends? You'll find them on Craigslist. That's all I can say.
I don't know. The dark web. I don't know.
Oh, anyway. Great memories. All right. I don't know what we were doing before this. Okay, back to a court hearing. Josh says he found something. Hang on one second.
Josh! Okay, weird stories out. Let's go to what we came here to do.
Hang on, there's an ad, Josh. Okay, there we go. All right. It wasn't from you. It was this one. It's from Judge Dad. Judge Dad, how long is it? 2:35:19. Hold, please.
I'd fill up the air with something intelligent, but I have nothing.
Judge McNally. Oh, that's not him. Judge Michael K. McNally, personal meeting room. Still not. Honorable Michael K. McNally.
Wow, this is just getting more and more formal.
Audible. Did I not speak clearly? Honorable Michael K. McNally.
That K.
There he is. Got him. All right. 2:35, and we're going to be at Miss Pratt. 29 minutes, 50 seconds. There we go. All right, Josh has one for us right here. Let's see what we got.
Jamie Lenore Pratt.
Okay, bye guys.
23W832353 A and B. Good morning.
Good morning, Judge. COP 82378 on behalf of Ms. Pratt. Ms. Pratt, state your name for the report.
You have to start your video, ma'am.
Pratt, Jamie Pratt.
What do you think I'm thinking?
She stands mute and waves reading, Your Honor.
Did she just hang on, ma'am? I don't know where you are. You're gonna have to stop. I need to see. You're not driving, right?
No,
You're just,
I'm not driving. I'm stable.
Where has she been? Where has she been? She just called up today, Lisa, said cancel the warrant. I want to go in front of the judge when she was supposed to be here. This case been going on since 23, Ms. Pratt.
Okay.
All right? It's way too old for me.
It's just a warrant. Everything that the case was about, I did the first ticket. I have my license. It's just a warrant that's holding me up. Anything that's involved in this case has been done.
It's just a warrant. You don't say
It's
that.
just a warrant. No. Is that what you said?
Don't say that.
It's just a warrant. That's the only thing that has to be there. I have my license are valid. That I don't even have that car, but I got the headlight fixed like within the week of me getting the ticket. I did not know I had to bring it back to Woodhaven.
Ma'am, I'd suggest that you at least acknowledge. I know it's impossible for some people to say.
Acknowledge what? That I got the ticket? I did get the ticket. My headlight was out. My license was suspended. I'm not denying that. And I've done everything to correct that.
Give her a new date. We're going to give her a new date for an arraignment and pretrial. Defendant has to appear in person for a pretrial.
That's not going to be able to happen.
Well, then you're going to have a warrant issued for your arrest again, okay? You're going to have a warrant issued for your arrest again.
She's in Virginia.
Because I can't come into the courts? Because I'm in another state?
I don't want to, listen, I don't want to do anything to inconvenience you here. I don't want to inconvenience you.
This is why.
Give her an in-person date. I'm not going to play this game.
Me either.
November 12th at 8. She's gone, Judge.
Good. November 12th at what?
November 12th at 8:30.
What an attitude. What an attitude. Case is outstanding since 23, and it's just a warrant. So she stood mute on both. I'm giving her a new date. She didn't allow me to set the bond. I'll set the bond when she comes in, okay? So November 11th.
She's not going to be there.
Wow.
She's in Virginia.
November 12th at 8:30. Jeez. What is happening? Huh? Can you tell me what's happening?
No, Judge.
I don't want to know. I don't want to know.
Can you tell me what's happening? I don't want to know.
Godfrey.
Thanks for that.
Richard J. Godfrey, 25F244515. Good morning, Mr. Haynes.
Mr. Godfrey's like,
yeah, I know. Well,
can I not
maybe
go
he's going to
next?
yell at me too. You never know. Of course, they're not as brave when they're in person, are they? Your name, sir?
Richard Godfrey.
All right. So, Mr. Godfrey here, we adjourned the sentence. What happened is, well, let's back it up. He pled guilty on September 29th, the failure to submit. September 16th and 18th. And now I've got calling Jessica. I've got failed to submit the biweekly testing she ordered on September 16th.
She's not going to show.
And failure to submit the biweekly testing is ordered on September 18th. So
he had already pled guilty to those.
Right.
Returned to the 7th.
I know. So I'm going to get Ms. O'Donnell in here. Has he been testing since then? Do you know?
No. So the issue was a matter of, I guess, what we call shy bladder syndrome.
Did he go and get a medical excuse?
Well, he went to the doctor. He said the doctor refused to give him that authorization.
They should look at me and said, no, I'm not going to do that, and walked out of the room. Yeah, I explained the whole situation to them, and they said, no.
Did we talk about this with possibility of a pat-down search? Did we talk about that?
What?
A pat-down before he tests?
We didn't talk.
If you don't have a medical document that tells me you have shy bladder syndrome, I can't conclude that you have shy bladder syndrome. Listen, please.
I understand that.
The idea that you're not going to test
Is that a thing? I didn't know that was a thing.
is not good. It's not going to happen. Hang on. It's not going to happen. I'm just telling you it's not going to happen. You called Jessica, right?
Yeah, shut him up.
How many other tests has he missed since then? Or not tested?
I don't know what this schedule is. That was 4 weeks ago, roughly.
All right.
Just hold on.
He didn't test.
So he did appear for testing. He appeared for testing on October 16th. He tried and he again was a CMU on that day.
CMP could not
You
produce.
can't pee in front of somebody. You can't pee in front of somebody, urinate in front of somebody. Is that the issue?
Yeah, that's indecent exposure.
Top close, you got 30 seconds.
Listen.
Yeah, no, I can't. If there's somebody not standing there, I still couldn't do it. I've had that problem my whole life. Told you.
Is DNA open today?
I know. Sure. Yeah.
Sir, you're going to have to test. You're going to have to test. Even though there's no shy bladder syndrome, and I always require a diagnosis of that for a pat-down,
Yes.
defendant to test today or first available day.
Look how quiet everyone in the courtroom is. They're like, the judge is on a mood. Don't make a sound.
Defendant permitted to have pat-down search before testing.
Select them to allow them to just like give them more time because even with the pat on the
Yes. I mean, tell them, be reasonable. I would find it hard to believe that they're not being reasonable. He's the only one that's come in here and said they gave you 30 seconds. I mean, I can only tell you if I don't have a test, it's not going to be nice. I'm giving you every benefit of the doubt here.
I understand that.
I'm giving you every benefit of the doubt there. I'll underline it, bold it. That's what's happening. You got to test, period. If not, you're going to have to go do blood work and you're not going to be able to afford that. I'm telling you. How much is a blood test?
Honestly,
A couple $100.
it's over $100.
It's more than that. So we'll adjourn the sentence. Hang on, John, I'm sorry. Adjourn the sentence about a week out or 10 days out, or when Mr. Haynes is here again, Lisa. You got to test. Okay? I know it's going to happen.
That's probably a couple hundred too.
I know it's going to happen. You're going to come back here and you're going to test positive. Okay, okay, good. Then we'll all be happy.
What? 76 days.
Good. Lisa, yeah, you got it. When are you available?
Judge, I've got arraignments next week on the 3rd, and then I'm doing over the phone on the 13th.
You think we can get that test?
Yeah.
By the 3rd, I mean.
Yes, he can be able to test this week.
By the 3rd, We'll adjourn it to the 3rd at 8:30. Is that good?
That's fine.
Okay. Adjourn it. Is that good, Lisa?
Yeah, that's good.
Good. Go talk to her. Thank you. She'll tell you when they're tested. All right. Now I'm going to try to move you guys out of here. My sincere apology. So we're going to move these out rather quickly. First of all, I want Nathan Michael Porter up here, 25T646-474 A and B. Could I have seated up here Amanda Miller? Your name, sir?
Nathan Porter.
All right, so you're going to plead to no proof of registration. That's on file A, and they're going to dismiss the no proof of insurance, right? All right, to that charge of no proof of registration, responsible or not responsible?
Response.
Is that what you're going to do, is plead responsible to that?
Can you please restate that?
Can you use it in the sentence?
This tells me the STIP form that you're going to plead responsible, admit responsibility to no proof of registration with the understanding the expired plate and no proof of insurance will be dismissed. Is that your understanding?
Correct, yes.
So to the charge of no proof of registration, how do you plead, responsible or not responsible?
Responsible.
Plea is accepted, original charge dismissed. That's the expired plate and no proof of insurance. 135, you can go right down the hall and take care of that. You're all set. Good luck. Thank you. Amanda Miller. Amanda Jill Miller, 25W840024. Good morning. Your name, ma'am? All right, so you're going to plead to impeding, right? You're going to plead to impeding traffic, correct?
Yeah.
Is that what you want to do?
Yeah.
To that charge, responsible or not responsible?
Responsible.
Okay, I'll accept your plea, dismiss the speed 150, and you're all set. Have a good day.
150, that's 150 bucks.
Palmer,
This court
Rosie
collects the
LaShawn
cash.
Palmer, 24W834225A and B. Your name? I have to arraign you on this unless you tell me you have the money. You have the money on these? You owe 248 and 362, which should be 610. Why are you waiting so long?
Well, nursing school in Ohio, and then so I have to pay gas money to my friend to take me, and then I was at work on the.
This ticket's been outstanding since April of 24.
I've been in school since
Where do you work?
Children's Hospital.
What do you do there?
I'm a school nurse next term, so my hours are going to y'all have been on.
I'll give you one more chance, but you can't do this again, okay? You can't ignore courts like this. You were supposed to be here for a show cause in August of 24.
Oh, I didn't listen to that.
All right, you pay $100 now on that case, and then you're going to set up your own payment plan. How great a country is this? Well, how much can you afford to pay weekly or bi-weekly?
$50 weekly.
You sure?
Yes, my mom says she can help.
All right, starting when?
The 31st. That's what I'll be paying.
All right, I'll make it November 3rd. You pay 100 now, then 50 weekly beginning November 3rd. That's on the A file, and then same thing on the B file if you can set her up and give her a plan then. Okay, Lisa? So we'll string that out. Listen to me. If you don't have the money next time, you call the court, we'll go on Zoom, or you walk in here on or before any of your due dates. I'll be glad to give you an extension, but you can't ignore courts like this. It never looks good. You understand?
Yes.
All right, best of luck. Christian Cornelius Stringer, 25T646470.
We're still talking
Can I
about
have
P
seated
and
at
check.
that table up here then? Darlene Barnard and Mansour Issa. Good morning, sir. Your name?
Christian Stringer.
You're 21? 20, sure. 20.
21 next month.
You know what drives me crazy when I'm going down the road? Watching people operate while texting. Don't do that. You're going to hurt yourself or somebody else. You're going to plead to impeding, right? Responsible or not responsible to that?
Responsible.
All right. 180. Okay? Original charge dismissed. Don't be doing that. I'm telling you. I can't believe people do that still. All over the road. Darlene K. Barnard. 5T646-465. Good morning, ma'am. Your name?
You guys are still
All right. You're going to plead to impeding traffic, right?
Yes.
How are you? I haven't seen you in a long time. You doing all right? To that charge, impeding, responsible or not responsible? Please accepted. Original charge dismissed, 150. Cashier into the hall to your right. Thank you. Mansur Naji Issa.
Compare this to the other traffic court
646-438. Could I have,
that dismisses everything.
is Issa out there?
He's made
Mansur
like $1,000
Issa?
since we started here. This court's cha-ching.
Is Mansur Issa out there?
Nope.
Can
Bench
you
warrant.
bring him in? Glenn Thomas Loop. 25W839714. He must be out in the hallway or. Okay, your name?
Thomas Loop.
All right, so you're going to plead impeding traffic, true?
True.
To that charge, responsible or not responsible? All right, I'll accept the
180,
plea. 155 is your total. Yes, you're in the hall. You're right. Good luck.
Thank you.
Does he just like guess on the amount? He just sets.
Kaylee Marie Gorecki. 25D149492. And could I have up here Caitlin Vieira and Robert Poma, please? Your name, ma'am?
Kaylee Marcus.
No injuries, minor damage. You're going to plead to impeding, right? Responsible or not responsible? I'll accept the plea, dismiss the original charge, 195. Cashier into the hall. Be careful, okay? Thank you. Caitlin Lindsay Vieira, 25B149587.
Your name?
Good morning. Your name? So you're going to plead the expired plate?
Yes.
Responsible or not responsible? Please accept. Do you have a valid registration now?
Yes.
You have it with you?
Yes.
Can I see it?
Can I run my car to grab it?
No, I'll take you at your word. 115. You're going to plead to that charge responsible?
All the
Expired plate?
All the
I'll
Caitlins
make
are
it
getting off
150.
easy.
I'll take you at your word. Good luck.
Thank you.
Robert Lee Poma.
Last Caitlin Rabbit.
25B149595. Your name, sir? All right. Good morning to you. You're going to plead to impeding traffic, correct? Responsible or not responsible? All right. 150. Original charge dismissed. Please accepted to impeding. You're all set. Good luck. Damian Stephen Tomov. 25B149199.
He wore a suit. He means business.
Mr. Tomov, good morning.
Good morning.
Your name?
Tommy Tomov.
What do you do for a living?
I work for City One.
I mean, it's just, you look good. Came with a tie on.
Came for occasion.
What's that?
I said came for occasion.
You're going to plead to impeding, right?
Correct.
Responsible or not responsible?
Fine.
All right.
Give him a break. He wore a tie.
All right. 160 is your total. Cashier into the hall to your right. Original charge dismissed. Amanda Dawn Igna. You too, thanks. 25B149457. I need Willie Deal seated at the table and Samantha Brecker.
Willie Deal? Is that his real name?
Your name, ma'am?
I'm in the egg.
All right. This has to go back to the officer. Can you have a seat right behind you, please? Thanks. Tell John to take that to do void. Willie Clifton Deal. 25F244438.
He didn't follow the instructions.
No, you can come right up to the podium there. Your name? All right.
I can barely see him there.
I don't like podiums, Your Honor.
What's the holdup, Judge? You just tell him impeding, dismiss the original charge, and you charge him out of $50 and it's done.
You got to be careful. I'm not even sure you deserve impeding here. You understand what I'm telling you?
Yes,
Why are you operating and texting? I mean, is there not enough advertising campaigns over that? I mean, I can't believe it. Why are you doing that?
Yeah, I was working at Curry, had a moving company right on Flatline. I was looking for a canvas and I was navigating. I was reaching on my windshield to take my.
To the charge of impeding traffic, how do you plead?
He doesn't want to hear it.
Not response. Don't come back and ask me for one of these again, okay? You got a not so good record. This is your second one of these. Went into default. I'll set aside the default judgment, 245. Just go down the hall and sign that bond over and you're all set, please. No more of that.
Okay, they issued me a point for that too, because I missed my court date. Yeah.
But we're gonna take it off. Conviction will be taken off the record.
How long does that take? So I can report to my insurance company?
He's dealing right now.
I'm doing it right now, Judge.
They're gonna do it today, right now, yeah.
It's coming off today. Thank you, I appreciate it.
Go sign your bond over. No more of that, please. Thank you.
Well,
did anybody locate Mansur Issa?
He's not on Zoom.
Samantha Diane Bricker, 25T646645. Good morning to you. Your name? All right. So you were going to plead to impeding traffic, right? Responsible or not responsible to that?
Everybody gets impeding.
Please accept it. 160. You're upset. Cash, you're into the hall to your right. Good luck. Yeah, I mean, how long?
60 days.
Where do you work? Give me that. I need her file, John.
I work for the Grading Solution.
I'm sorry?
Payroll Grading Solution. But I just went back to work 2 weeks ago.
That's a lot. You're asking me for a lot. Do you have a husband, married, or kids?
She just went back to work from maternity leave, and I've been here a single mom in that.
Okay.
4 weeks.
All right. Good enough. Good enough. Can you pay $30 per week starting in about a month?
Yeah.
You pay $30 due each week, beginning on November. I'll make it November 24. Listen to me very carefully. If you don't have the money,
Right
no
before
problem.
Thanksgiving.
Call the court. We'll go on Zoom and give you an extension. Okay?
Thank you.
All right. Or you can come in here on or before your due date. Just on or before your due date. All right. Thanks. Mansur Issa in here?
I checked outside, Your Honor. He's not out there.
Lisa, I think we're just going to reschedule this. I don't know why he thought he could leave or.
All right. Speaking of thinking I
But
can
I
leave.
don't see him in here. I've called his name multiple times.
Bench
John
warrant
called
shall
his
issue.
name in the.
All right, we're done. We're done. I'm jumping on him.
So I'm simply going to say
Bench warrant.
defendant, reschedule.
Lucky.
Defendant must have left.
He left. All right. Now we're done. We need a sample before he can leave. I don't know. I'm really shy about that, Greeners. So good luck getting that. Trying to leave. I'm trying. All this talk about pee and suddenly I need to. So no, it's good. All right. Fun day today. Fun day tomorrow on tap. Also, we have Mr. Farag, who's supposed to show up on Wednesday. We're going to be watching for that. Tomorrow, I think we've got some Judge Cedric Simpson court possibly that we need to be watching for. So we'll do a lot. What did the not guilty? What did it show? 97% guilty for our group. But that was before the judge gave the very defense-friendly instructions. I've already cleared my Wednesday for Farag. Wonderful. That's great. No, we're on childbirth now. Yes, for those that don't know, my son's child is going to be a girl. Well, it's a girl. We just found out it's going to be a girl. So I thought I'd let you guys know, pass that on. A couple of you asked when I find out the gender, and it was yesterday. So, all right. Thank you all. Thanks to Mrs. R.A. for coming in and saying hi. It's been a while since we've had her on here. Tonight when you go home. Oh, wait. You can't do that until you do this. There you go. It's 4:15. We're going to wrap up today. Remember, Wednesday, podcast. Friday, Halloween live stream. It's going to be great. We're going to give away a lot of candy. I went out. I don't know where they are. I went out and I bought 4 more little string shooters, those little handheld things that shoots the string. And I'm going to give those out. Don't tell anybody. This is a surprise. But I'm going to give them out to people who have the best costumes. So I've got 4 more to give away. When I see a kid who's just really rocking the costume, the whole Halloween spirit vibe, we're going to give that as an extra bonus in addition to the candy. So I've got 4 of those to give away as well to the trick-or-treaters, because that'll be fun. And I think that's all. Frog, Halloween, Verdict. It's going to be a great week. Don't miss a moment of it. Make sure you click the subscribe button if you haven't already. I think all of you have. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning, 8:30 in the morning. It's the start time because Judge says we start at 8:45 and we don't want to miss a thing. Don't want to miss a thing. So I'll turn the sounds up for you just for a little bit as we finish things off.
The zombie apocalypse may be
there you go. You
upon us.
found it already. You guys have a great one. We'll see you tomorrow. Bye-bye.
Hello.
I'm not a camel.
Hello.
No.
Hello.
Thank you, sir. You're my new best friend.
Hello. Hello.
I don't like podiums, Your Honor.
Hello.
Because he's the guy.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Hello.
Are we going to address subject matter jurisdiction?
Hush! You're talking about stuff that is not relevant.
I was kicked back, taking it easy.
In front of the Walmart.
I was told counsel wanted to see me inside back.
Hello.
Alex Stoller.